Additional correction, my lord. Last line, my lord, kindly.
Leave to file without a certified copy of order, my lord. So I've
Yeah,
challenged
what is
three
the
orders.
urgency?
No, the urgency is, my lord, I have a award for eviction against me. The award debtor is holding on to the possession of the property without paying any occupational charges, which are the tune of 40 crores today. My execution
When
application,
the order was passed?
my lord, the execution was pending since 2017.
Yes.
There was an award. The award has now been upheld by the division bench of this court. There was initially a
What is the urgency? Can you not file after getting the certified copy?
some urgency, my lordship
What
is
is the
aware, my lord, execution cases, my lord,
Thing will happen.
lordship
Please obtain the certified copy and then file.
May it please your lordship to mention a matter, my lord. This is with regards to that custody matter, my lord, where I am for the opposite party, your lordship. The learned advocates were appointed as special officers.
Yes.
I have filed an application yesterday, Can 3, my lord, in that matter. I am urgently wanting to move that application because the next visitation is today, my lord. I am seeking suspension of the visitation for the time being.
Today it cannot be
Your
possible.
lordship, at the earliest, my lord, if your lordship kindly.
Please mention tomorrow.
I am agreeing for the opposite party.
Yes,
My
please
lord,
mention
since the
tomorrow.
visitation is today, my lord, kindly
Nothing will
consider us.
happen. Yes.
And I'm mentioning for upgradation of item number
Please
920
come tomorrow.
for trial, my lord.
Nothing will
I
happen.
have your lordship's leave, my lord, to mention item number 140 of your lordship's list, my lord.
Yes.
But this matter was taken up on Saturday, it was disposed of, my lord. It's still appearing.
140.
140, my lord.
140 টা দেখে নিন।
My lord, may I have
140 টা দেখে নিন। সাপ্লিমেন্টারি লিস্ট
Sure.
140 টা ডিসপোজড অফ হয়ে গেছে বলছে শনিবার।
May I have my lord's kind leave to mention a matter, your lordship? Your lordship, this is a civil revision from an order passed by the Real Estate Regulatory Authority, your lordship.
From the
Real Estate Regulatory Authority, your lordship.
yes.
Your lordship, I'm humbly praying before your lordship to grant me the leave to file the civil revision without the certified copy
Why?
of the.
What
Your
is the
lordship, there is
urgency?
some urgency, your
What
lordship.
is the urgency?
The judgment was passed by the learned authority ex-parte, your lordship.
When
Not
the order was passed,
22nd July, your lordship. The matter has been directed
you have
before
applied for the certified copy.
Yes, your
When
lordship.
are you expected to get the certified copy?
Your lordship, in 3-4 days, your lordship.
File with the
Your
certified
lordship, the
copy.
urgency is the matter has been directed before the district magistrate, your lordship.
Yes.
If the district magistrate takes any step against my client, my
Please,
client would be.
Till 3-4 days, nothing will happen. Yes,
Lord-
please file with the certified copy.
This matter,
Much obliged, your lord.
come on the monthly list of August, my lord, but it has not come.
Please come tomorrow.
We
Please mention
considered to
tomorrow.
mention for the correction.
Correction, hand over the.
my lord, lordship leave to file this application without a certified copy, my lord. The matter is fixed on 6th, my lord. This is an order from of the collector, my lord. They have dismissed our application and the application is sent back to the SDM, my lord. So from that order, I am challenging, my lord. We have filed a requisite before the collector for the certified copy because
The order was passed.
my lord, 4th July.
4 July.
And on 6th, my lord, the
When
collector,
did you apply for the certified copy?
my lord, last week, my lord.
Why? You
My
have
lord,
delayed.
Manoj,
File with the certified copy.
actually, we were contemplating. We filed a writ petition also. We are trying to file a writ
If
petition.
you could wait subsequent long time, please file
My
with
lord,
the certified
on
copy.
6, my lord.
No,
My lord,
nothing will happen.
will be highly prejudiced, my lord. Kindly, my lord.
Applying for the certified
No,
copy.
we are contemplating filing a writ petition. There are the senior advocates said that we need to file a 207, my lord. Kindly, my lord, leave me granted, my lord.
When you will be getting the certified copy?
My lord said 15 days. They said 15 days.
15 days.
Yes, my lord.
Whenever you applied, please give me the, whenever you applied, I will expedite the certified copy. Whenever you applied, please give me
They
the,
have not given a receipt also, my lord.
please, please inquire, please give me the, show me the receipt, I will expedite the certified copy.
No,
My lord, they have not given the receipt, my lord. That's what they are saying, my lord. They have not given the receipt also, my lord.
You have applied,
But for that, they
must be
say
having some document that you have applied. Whenever you applied,
apply copy to that. Last week, my lord. Last week, and they are saying now
give me the date when you have applied.
after 10 days, we'll give the receipt, my lord. They have said that, my lord. After 10 days, they will give the receipt, my lord. Last week,
Receipt.
the receipt of applying
District.
my lord, Barasat court, my lord. Barasat.
You are saying court or Barasat district
Barasat,
magistrate?
my lord, district collector, Barasat, my lord.
District collector Barasat.
Barasat, yes, my lord.
Please come at 2 PM. I will inquire. Please come at 2 PM.
No problem.
May I be permitted to mention, my lord, item number 334 of your lordship's monthly list, my lord. The urgency is, my lord, there is a money suit.
You want upgradation?
My lord.
Please come tomorrow. Yes,
Okay.
to the list.
Item number 1.
Lordship, I appear for the respond number 10 in this matter.
Yes.
Respond number 10.
It has perhaps come at their instance. It is not at my instance.
No.
No, this is also not my mine.
It has been pointed out that the number of these writ petition was wrongly recorded as CO 4825 of 2005 instead of WPA 4825 of 2005. Let such error be rectified. This order shall form part of the order dated 1st of August 2025.
My lord, I have seen in the olden days, my lord, the writ petitions also used to have that CO number.
CO within bracket W.
My lord, I am grateful.
Yes, next.
Gratefully.
Lordship, item number 2 and 3, Ms. Jagriti Bhattacharya is for the petitioner Lordship. According to your Lordship, last order dated 15/7/25, Lordship. The
For
certified
the opposite
First time appear for this. My lord,
Yes.
I am praying for 4 weeks times to file affidavit in opposition.
What affidavit in opposition, sir?
Um,
What affidavit for what?
For what, my lord, the petitioner suppressed some material facts before your lordship.
Sir, have you seen the last order?
Yeah.
Yes.
Lordship, the certified copy of the mediation report has been.
Mediation report, the certified copy was not with them. For that it has come. And you will file affidavit in opposition.
Lordship, I've applied for it already.
You have a copy of the mediation report also. Show me the copy of the mediation report.
I'm not collecting.
You are saying they are suppressing and you are not having those documents.
Lordship, the certified copy has been applied for, but it has not been received yet, Lordship.
Yes.
Because the
other file has come because according to you, it was in the other file.
Yes, Lordship. The record is lying in the court. That's why the department could not process the certified copy. I have been told.
Yes, sir. Why have you not withdrawn the matrimonial suit number 766 of 2020?
My lord, after the mediation,
Yes.
petitioner wife filed 2 cases in Ranaghat. One is under DV Act, miss case number 03 of 2004, 2024, on 2/1/2024.
Yes.
And another is 406 and 34.
No,
All-
before the mediator, you agreed that you will withdraw this matrimonial suit number 766. They will withdraw matrimonial suit number 210.
Yes.
Why have you not withdrawn? I'm
My
asking you.
lord, I filed this case for only two sections. One is cruelty, and after the mediation,
You don't want to withdraw that.
till not.
Then their matrimonial suit also have to be restored. Then that also has to be restored. Please take instructions. I am keeping it in the next week. Then their matrimonial suit also has to be restored.
Lordship, may I be allowed to fortnight's time, Lordship, for the certified copy?
Yes. Then that has to be restored also. You have withdrawn your matrimonial suit. That has to be restored. Please take instructions from your client. Then that also has to be restored. Then you fight amongst yourselves. Ashun. The learned advocate
My application, my lord. My mistake, my lord. If my lord sees the first order 1970, very interesting point. My lord, whether,
Interesting point. What
Yes,
is the
but-
interesting point?
my lord, whether the information to be provided under right to information, kindly see the, my lord, the points have been 19 September.
No, under, why it has come up? Extension of
My
interim order.
lord, 31st July, it has expired. My lord,
So how can it be extended now?
come back and file an application. My lord,
Why have you
difficulty
not
is-
filed?
my lord, it came to my knowledge belatedly. My lord. The department called me up and said the interim order had expired. Thereafter, I mentioned the matter. If my lord grants some extension because it is there from September 2024.
Who is for the other side?
But he is not appearing. Man, this is the affidavit service. My second, my lord, first round also he did.
Affidavit service filed in court today is taken on record.
Here on behalf of the petitioner, Malad. This order, Malad, was passed in the month, Malad, on the 22nd of January, 2025, Malad.
Yes.
And Malad, this order was directed to remain in force till the end of July 2025. Malad, the contesting respondent here is a cooperative society. Pursuant to the order of the court, Malad, we have effected service of the petition and the order upon them. But Malad, unfortunately, this is an affidavit of service. Malad, they have, despite service, not chosen to appear, Malad.
You have sought upon the learned advocate.
Yes, Malad.
Yes, Mr. Nayak is appearing.
Malad, they are appearing for the state respondents, Malad.
Yes.
So, Malad, I have served upon the private respondents as well. Malad, that was the
Yes,
cooperative
Mr. Nayak,
society.
what do you say?
I appear for the register, not for the society. The society answerable
But
responded.
I am extending the interim order.
Yes, Malad, that was what I was
affidavit
beseeching,
service
Malad.
filed in court today. Next.
Item number 6. Grateful, Lordship.
6 minute, I'm appearing for the petitioner. And I'm seeking expeditious disposal of my application for restoration.
They have served money, I am the opposite party.
Well, I essentially seeking, my lord, an expeditious disposal of the, my lord, my application for restoration of the suit.
Restoration of the suit.
Yes, my lord, suit was, my lord, dismissed.
Why it should be restored, Mr. Chatterjee?
My lord, I have explained in my order application, my lord, what happened, my lord, as the erstwhile learned advocate was not taking steps properly, my lord. I changed the advocate and then I came to know that the matter was dismissed for default. My lord, then I filed an application, my lord, on,
Yes, what do you say? He wants the expeditious disposal
I
of.
have no objection, my lord, because they filed an application after dismissal, my lord, they long after.
They want to delay this, what can be done?
Yes.
This application under Article.
my lord, I am for the petitioner. My lord.
Yes.
I have, my lord, I have come before your lordships for expeditious
Disposal.
disposal, my lord. The title is first, my lord, I have served, my lord.
Why?
Then,
Why have you served? That is what I am asking you. There is no
Then no-
caveat and you have served.
lordship,
Yes, what is the stage of the suit?
my lord, hearing stage, my lord.
Hearing
there-
stage.
My lord, there was
Evidence
a
completed.
lordship.
Evidence completed.
No, my lord. And the matter was filed in 2021 and Lanet Court is.
Repairing application is pending, sir. How to say it's at the hearing stage?
Order 39 Rule 1 and 2 was being heard. Means ad interim was refused. They went in miss appeal unsuccessfully. Thereafter, Order 39 Rule 1 and 2 was finally being heard. There was it was fixed for that. In the
Rule 1 and 2 is still pending.
trial has not yet commenced and more application for Order 7 Rule 11. That was being heard. Order 7 anticipating that there will my application for repairs and maintenance is fast, my lord. I am in a very critical situation. Kindly come to
This application under
the 77 years old person is the plaintiff suit for
What do you want?
Lordship, I got decree from the learned civil judge junior
What do
division.
you want?
Appeal is pending. Lordship, kindly within a specific period, Lordship, let the appeal be disposed of. Because 3 occasions it was given last chance to the appellant defendant. Lordship, kindly order number 2021.
What up? Next date is on 27th of August.
Yes.
The appeal, what is the decree for?
Decree declaration of title and permanent injunction. I got the injunction. Permanent injunction.
Permanent
I got.
injunction.
Yes. Lordship, the judgment and decree starts at
This
page
application
20.
under Article 227 of the Constitution.
Lot 9, my lord, the defendant is the petitioner before your lordship. The suit was filed by the plaintiff being the husband of the defendant for a declaration and permanent injunction. He got an order of injunction restraining the wife not to cause any disturbance. My lord, the plaintiff husband was residing at Itanagar, the matrimonial home where the parties were staying, my lord. It is in Kolkata.
What do you want?
My lord, kindly seize 2 orders. My lord. Before that, my lord, I will just place the short brief, only 1 minute, my lord. My lord, thereafter, he has put padlock in the matrimonial home, for which I am not in a position to enter the matrimonial home. I was outside. I made a complaint, police complaint, so that the padlock is opened. No action taken. We moved before this honorable court an application under Article 226. But an order was passed because of the pendency of the suit. Liberty was granted to me to approach the lower court, to the trial court. We have made an application, one for vacation of the interim order and one under 151 for removing the padlock. Dates were fixed. No specific, your lordship, I have annexed the entire order sheets, my lord. Automatically, interim order is being extended. Thereafter, we came before this honorable court, an application under section 24 for transfer. An order was passed. Your lordship, kindly.
Why transfer?
Transfer because my application is not being taken up. Every day, second of matter is being fixed. Your lordship, kindly sees date after date. I have annexed the entire order sheets. Date after date, it has been done. No specific hearing, nothing, only extension. And thereafter, my lord, we came before this honorable court. An order was passed under section 24, not in true sense section 24.
Yes.
Lordship kindly
It
sees.
has now been transferred.
No, the other coordinate honorable judge have directed the learned trial judge to fix up the hearing and dispose of the matter within a particular period of time. On contrary, my lord, your lordship kindly sees the two orders, which is, my lord, hassle before your lordship. Order is dated 3rd June 2025.
3rd June.
3rd June 2025.
No, passed by this court.
No, the order passed by this court is at page 83.
Yes.
83. It was the trial court was directed to specifically dispose of the application within 8 weeks. Now this was communicated. Your lordship kindly sees the order dated 3rd of June 2025.
Passed by the trial judge.
Trial judge.
3rd of June.
Photocopy of the order in passing CO number such and such. Heard the defendant on the prayer of the plaintiff and ad interim order of injunction be extended till such and such. Both parties to remain present at 2:30.
Now 20th of August is being fixed.
My lord, your lordship kindly sees 20th of August after 8 weeks. Lord, in complete violation, my lord. I must say.
Test steps.
No, my lord.
Test steps for violation.
Lordship kindly sees the entire order sheet.
The trial judge has violated the order of the High Court. Please take steps.
Lordship kindly sees the entire order sheets from order number 1. One line orders, extension, no steps. Lord, my entire.
Well, this is the difficulty in passing orders for expeditious hearing.
Now,
because we do not know the business of the trial judge. So that's the difficulty.
Most humbly, I am submitting, my lord.
That is why fixing a time limit.
There must be an endeavor, my lord, to take up your lordship kindly sees a matrimonial suit going on. I am the wife. I was prevented.
All matters are urgent. All parties have an urgency to move their matters. Fixing a time limit.
Outside the matrimonial home, no order. Your lordship kindly sees the injunction order. Injunction order
151 police cell. You want implementation of the ad interim order with police cell.
No, order 39 rule 4 for vacating and 151 to enable to there is a direction to open the padlock.
That means, Mr. Shamul, your allegation is that in violation of an ad interim order of injunction, padlock was put.
No. He obtained the interim order. The husband obtained the interim order.
That is what I am saying.
He put the padlock.
That is what I am saying, Mr. Shamul, that you have obtained an ad interim order.
No, it's not me. The husband plaintiff obtained. I am the defendant wife.
Yes.
He obtained an interim order.
Yes.
Not to create any disturbance.
Yes.
Thereafter, he put the padlock and he went to his place of work at Itanagar. I am not been able to enter the matrimonial home. That is my difficulty. My entire belongings, my testimonials. I am an officer working with a nationalized bank. My entire things are, my lord, stuck up in this. That is my urgency.
151 cannot be decided. Yours order 39 rule 4.
No, my lord. There is a application.
There is an order of injunction operating against.
An application.
So there must be some prima facie finding that he was in possession, you are not in possession.
Kindly sees the injunction order. My lord, your lordship kindly sees the
I'm directing this order 39 rule 4 and 151.
Kindly for my satisfaction see the injunction order. Kindly sees the injunction order.
Yes, page.
The first order, my lord. The bunch of the orders, certified copy.
And you have also moved before the writ court also.
No, after padlock, because I am helpless. That at that point of time there was
vacation. Civil suit is pending.
The honorable writ court directed me to approach the civil court.
Yes, rightly.
But I approached the civil court.
That is why.
The civil court not taking steps.
Yes.
Lordship kindly
page.
My lord, the prayer of the ad interim order, your lordship got?
No, page.
Certified copy. The order dated 1st of August.
Oh, in the certified copy.
My lord.
Oh, you have obtained the
entire sheets, my lord, just to.
Which order?
Your lordship. Order dated 1st of August 2024. The lordship says the prayer for ad interim ex-parte injunction is allowed. Defendants are hereby restrained from creating any disturbance in the peaceful possession and occupation of the plaintiff in the suit property till such and such. innocuous injunction order. Thereafter, he put padlock. He is staying at Itanagar, instituted a matrimonial suit there, and I am not been able to. At that point of time, I was in office. I was attending office. And my application, my lord, kindly see. My grievance is that the learned trial judge ought to have taken into consideration the urgency involved in the matter.
Yes, 20th of August is for hearing of the Ashun.
My-
This application under
10 lordship, I'm for the petitioner lordship.
Yes.
This is a peculiar case lordship where
Peculiar case, why? What's the peculiarity in that?
order 41 rule 23 has been filed by the appellant during the pendency of the appeal. Due to the fact lordship, the order
That has been allowed.
no, not allowed, rejected.
Then
I'm the defendant. I have filed this application under order 41 rule 23 that has been rejected.
rightly,
Lordship, what has happened, Lordship? The
or
order
it be decided prior to the hearing of the
that
appeal.
is the findings of the trial. court.
Correctly.
Because of the fact, because the original defendant,
Right, the evidence is already on
no
record.
evidence was not completed. That is what let's
So the appellate court will consider that if the judgment cannot be pronounced, the appellate court ultimately will remand the
earlier
matter.
order 41.
Can that be done at an interlocutory stage prior to
That is
hearing of
why
the appeal?
I started my submission in that way. Order 41 rule 27 was allowed. The evidence was going.
Rule 27 was allowed, could not have been allowed
Oh, no,
prior to hearing of the appeal.
No.
Could not have been allowed in isolation. So I'm setting aside that order also.
No, that order has gone because what has happened, Lordship, that original defendant was adducing evidence, but it could not be completed.
Mr. Rai, that
Lordship
might
will
be a
say not
ground for.
necessary order. I have seen it, Lordship. That is why I have started with that statement.
Thank you. Uh, This application under Article 227 of the 11.
Your Lordship, I'm for the petitioner.
Yes.
My lord, I am appearing on behalf of the respondent.
Yes,
Lordship,
my lord.
we have filed the vocalatnamat today, my lord. I'm praying for not this week.
Why?
We don't have the petition, we don't have the
Lordship, there
instruction.
was no caveat. We had already, it was quite
Not
agitated
also the
and
caveat, madam.
My lord, I'm
Let
praying
me
for
hear.
not this.
Yes.
Your Lordship, this we are coming for the challenging the order dated 30 June 25, where the ordinary jurisdiction of the child was challenged after ages. That's the wife, I am the husband. I have filed the petition in the Raiganj court in 21, December 21. Since then, the wife has been appearing. Father, she has been filing even in 2022 she filed a 498, then went on filing custodial contesting the custodial, then went on filing the 125, whereas at the end recently she went and filed before the lower court that she wants to change the jurisdiction. Now, my lord, it is a proven fact that the child has been in the school, has been appearing. We have annexed it in the annexure A. If you page number 16 onwards.
Yes.
my
What
lord.
is the order impugned?
The lower court erroneously say that we can transfer the order on the ground of ordinary jurisdiction. It's a
Where
settled
the
fact.
child,
It
where
is a settled
the,
fact.
where the
Yes,
child is now residing. At the time of filing of the application,
the child has been here. The child was here. Ordinary jurisdiction, my lord, has
madam,
been.
I'm asking you where the child was residing when the application was filed.
My lord, the child had been to and fro in my house and to the matrimonial house.
You are not answering my question. I've asked you when this application under the Guardianship Words Act was filed, where the child was residing.
The child was residing with the mother.
Where? Place.
This was in Farakka.
Yes,
Farakka is in the district of Murshidabad.
Yes.
And where we have filed this application,
This was in Raiganj court, my lord.
can it be done?
My lord, she had
Quickly.
been appearing. She did not agitate this particular fact for all this while. A visitation right, when it was passed, that at least the father can see the child. When that was passed, she went and filed this, my lord.
File before the district judge Murshidabad.
My lord, already the justice judge has passed the order that it is not in the capacity of the judge to hear it at this moment.
Yes, because the Rajganj court do not have jurisdiction.
My
That's
lord,
why.
it's a settled fact that the child, if on a forceful removal, cannot change the jurisdiction. My lord, we have a lot of precedents. If your lordship kindly indulges into the fact, we have settled judgments of the Supreme Court.
Show me a settled judgment of the Supreme Court which says if a ward resides in a particular place at the time of filing of the application can be filed
My
in
lord,
another place. Show me that.
if you just indulge into this fact, my lord, the wife has been contesting the matter for all this while. Suddenly, when the father got the visitation right, just at least for the seeing the child online, that was never complied. Suddenly, she went and filed the jurisdiction, whereas she has been to and fro.
I can hear you. I can admit this civil division application. I can direct you to serve, but then till then it will be kept pending. Or you can.
If you indulge into that much, that would be a lot, my lord.
All right.
We can come back with the judgments also.
Your Lordship, may I submit one?
Yes.
Your Lordship, my lord, as my father expired last night, Your Lordship, I just got this information from my client today morning, and I know we have not filed yet. My lord, kindly 1 week time I need. I will come up with all the documents, Your Lordship. My lord, kindly I need some time.
Yes.
But we already have a CO pending. That is also there.
You for what?
For expeditious. My lord, this has been pending for ages.
Expeditious. This
For the hearing.
What can be done now? That has become infructuous. Directing return of plate has been allowed.
My lord, it has been allowed in the lower court to come with the judgment of.
There is no proceeding nowhere. You are at that stage. Neither in
What can we do? I'm
in Uttar Dinajpur or in
I'm
Murshidabad.
just a father making the humble submission.
That is why I told you That is why I told you. So now there is no
My
proceeding
lord, may I interrupt?
at Uttar Dinajpur or at Murshidabad.
My lord,
My
it's
lord,
Uttar Dinajpur. We have the next
my
date
lord,
on.
instructions, my lord.
It has been returned.
Absolutely, my
There will
lord.
be no date thereafter.
There has
Yes,
been
sir.
given a date. We're just waiting for your
The
order.
order impugned. The application under order 7 rule 10 was allowed, thereby directing return of the plaint to the petitioner herein for filing the same before the learned district judge, Murshidabad. Before before the learned district judge Murshidabad on July 30, 2025. First of when this matter is taken up for hearing, Ms. Such and such learned advocate appears and submits that she has instructions to appear on behalf of the opposite party. First, the petitioner is directed to serve a copy of this application upon the opposite party upon the learned advocate for the opposite party when
Within a week's time.
within a week from date. First up, list this matter under the heading motion in the monthly list of September 2025. Yes, next.
Obliged.
Your lordship.
Yes, next.
Item number 12. I am for the opposite party. Now, all my documents have been conveniently removed in the civil revision application.
All your documents
The
have
document has not been annexed.
You have said removed. I thought what?
No, I'm sorry. Alan has not been.
Yes,
Have
Mr.
served
Lahiri.
the- but this is a
You have not annexed all the papers which were before the learned.
I have annexed the plain written statement, written objection. They have filed some
You have
documents
served
by way of
a copy of
fiduciary.
fiduciary?
Am I supposed to annex everything? Well, I have challenging everything is
My
there, my
documents
lord.
are in finished.
He can rely.
Well, may I
He can
have?
rely.
Please appeal all the documents supporting.
Yes.
I've served them.
Then place
Yeah.
those documents.
Yeah,
There
I've
is
been
no
served.
difficulty
I've
on
been
that.
served.
Yes.
Kindly comes, my lord,
What is
to the
this?
findings, my lord. My lord, the suit is for declaration.
What is this?
These are the documents which we filed in the appeal court.
Appeal court.
Appeal court by a fiduciary.
All right. Yes.
Contest
My documents are
their
also there.
documents.
I'll rely upon this.
Yes.
Now, my lord, the suit
Sorry,
is for declaration filed by my lord persons who are my lord whose ancestors are recorded in the CS record of rights. Now, my lord, when the mining company came and started extracting coal, which as if today appears that this is an open cast mine, and my lord, they at that relevant point of time, I my lord approached the my lord court below, and my lord there was an order passed in my favor. Kindly comes to the impugned order. That particular portion of the order has been quoted there in the.
That is the trial court's order.
Yes, trial court's order is at page. This is his order. Page 40.
40.
0.
Why have you not filed a certified copy of the trial court's order, Mr. Lahiri?
I have filed this certified copy of the appeal court's order.
Trial court's order
Trial court's
also has
order
to be
certified
filed.
Certified copy filed by any
That's the appellate side rules.
Achha.
Yes, Mr. Mukherjee, any amendment to the appellate side rules?
227 last order, that is why my lord.
Oh, Mr. Lahiri. All along, this certified copies of, if you challenge,
Both.
yes, certified copies of both.
Yes. Well, kindly.
Otherwise, it's not in form. I cannot look into it also. Yes, proceed.
Page 40, my lord.
Yes.
May I just place it, my lord? Both the parties, my lord, brief account of the injunction application as follows. The scheduled suit property was originally owned and possessed by Nimai Bagh and Bagh to extent of 8 ANA shares and CSRS plot number, record of rights. The plaintiff, being the legal heir of the Nimai Bagh and such Bagh, inherited the suit property and are in possession of the same for more than 30 years. Plaintiff alleges that on such, the defendant number 3 and 4, this is the mining company, encroached upon the suit land for the purpose of excavating it by claiming that they have acquired the suit land from the defendant numbers 1 and 2. Plaintiffs filed an RTI before Block Land and Land Reforms Officer Khaira
Acquired the land from defendant number 1 and 2. Who is defendant number 1 and 2?
Defendant number
Where is
1.
the plaint?
Yes, plaint is
1 and 2 is the state of West Bengal.
Yes.
And the Block Land and Land Reforms Officer.
Yes.
So, it was acquired.
But that is the case. Now they are showing certain documents, but contention is that there is no records, there is no notice that they have annexed or relied upon as to how this has been done, under which act there has been acquisition. They say that my lands are vested lands. Record of rights have also been annexed. There are discrepancies that I'll show. In support of the case, may I just place the second paragraph? In support of their case, plaintiffs filed received copies of RTI such and such. Inter alia, defendant number 3 contested the present application or filing written objection and denied each and every averments of the said. Defendant pleaded that suit plot is a forest land which was diverted for coal mining project and delivered to possession to the answering defendant. Another suit plot number 164 is a government vested and recorded in the collector's khotia number 1. The suit property situated within the mine boundary was allotted to WBPDCL by the Ministry of Coal, and they were subsequently given on lease by the concerned authority for coal mining purposes. Accordingly, he prayed for rejection of the instatement. In support of the case, he has filed certain manner. Next paragraph. Now let us consider. It is the suit for declaration and permanent injunction. After going through the documents brought on record, this court finds that the plaintiffs came to be the owner of the suit property on the basis of CS record of rights in the name of the ancestors. The defendant, on the contrary, claims that the suit plot number 4 is diverted for the purpose of coal mining project by the concerned authority, and suit plot number such and such is vested. In support, they have filed plot information which shows that suit plot number such and such belongs to state of West Bengal. From the inspection, it appears that some excavation have already been started in some portion of the suit, and the rest of the suit property is forest land. Plaintiff in their pleadings have alleged that excavation being going on by the defendant. After considering the facts and circumstances, submissions made by the council in support of this court is of the view that if the suit property is not preserved, then instant suit will become infructuous and the plaintiff may suffer irreparable loss and injury. Therefore, an order in form of status quo with regard to respect of the suit property in question shall be passed in the interest of justice. Now, my lord, why this has been passed? Because in this particular facts of the case, if this is an open cast mine, the property itself will go. If they continue to continue to mine, or proceed with their mining activities, they will be extracting everything. There will be no land basically. So that is why, considering that, this particular order was granted. Now, my lord, kindly comes to the order impugned, and my lord, the documents as annexed. Before that, my lord, I'll just show one document from the
Mr. Lahiri, only one thing.
Yes.
If let us for the present assume that you are the owner of a particular land.
Yes.
Now, if it is detected that there is a mine, coal mine there, so are the government not entitled to acquire that?
That is a process.
So now,
due process has to be considered. Yes.
So now, if that is so,
yes.
So the government can acquire by a process, and you are entitled to compensation.
That is an acquisition process.
Acquisition process, or you are entitled to compensation.
Yes, yes.
So the fact remains there is a coal mine there.
It appears so.
Yes. So it's not in dispute that there is a coal mine there.
Yes.
So if you succeed, Mr. Lahiri, in the suit to show that your ownership still is retained, then it can be acquired. You are entitled to compensation.
My lord, prior to that, in view of the fact that they have, my lord, claimed, and in any case, I'll be showing
the mining operation going on.
Yes.
So prima facie, there is a coal mine in those plots. So your ownership, yes, it will be decided in the suit. If you are the owner, so you will be compensated by that.
But my lord, without showing any document, I would have understood a prima facie case has been made out.
Mr. Lahiri,
they have
not that there is a coal mine is not in dispute.
My lord, it appears so that they have been handed over possession, but
not produced anything.
I will
show that there is no coal mine. That is not in dispute.
But I will
extraction in coal mine, that is perhaps not disputed.
The reasoning of the learned court in the impugned order is with regard to the fact that if the extraction doesn't go on, there will be disruption in power supply and public at large. But this is
public
there is a huge place, huge
ground. Mr. Lahiri, that's also a ground in public interest. So that is also
Malad,
a
these are Malad,
refusing to injunction because you will not suffer if you.
Malad, my land will go, but there will be no demarcation, there will be no process by
that
which.
is why I told you. If there are two things, because mining activities when it is being going on, so
They have just
prima facie,
started. They
yes,
have just started. They have annexed documents by
there's
which it will
nothing-
be appearing that
you have not produced anything to show that there is no landmine. That is, there is
but
no.
that is they have asserted. I cannot, Malad, make
Yes.
assertions in
But
negativity,
that
Malad.
if you can prove that you are the owner of the property which has been wrongly taken away, utilized by the defendants, your right is to compensate for.
Malad, if the land itself is not there, Malad, if the land itself is not there, by the end of the mining
Compensation.
activity, Malad,
Compensation
how it will
for
be, Malad,
coal mine-
compensated, how it will be quantified, Malad, that is nothing. They have to show. I would have understood.
Compensated, acquired is by virtue of a statute.
Yes,
Statutory right.
I Malad, bow down to your lordship, Malad. If there was one, Malad, document produced to show what is the due process, was it Act 1, was it LR Act, how this has devolved and how they have,
you
have
have
only-
placed one while you were pressing the trial courts.
they have placed.
Tier number 1.
Yes,
So it's a
then
vested land.
Malad,
So it's
land records have been produced from where it will appear. It is Khotia number 1.
Yes.
So
It's a vested land.
Link as to how, because there are also
Mr.
rights is also
Lahiri, you
there.
have to challenge that vesting order.
Malad,
You have to challenge that
they
vesting
have
order.
to show how this has vested, Malad.
Mr. Lahiri, you have to
I
challenge that.
understand.
Challenge that vesting order, they will show.
But the CS records are there.
Maybe
Malad,
CS records
only
was
it
there.
has to be balanced. There is a CS record. Kindly come,
Yes.
Malad, to the bunch of the records, Malad, handed over, Malad.
So
Kindly
it
come.
was in Khotia number 1 in which records?
Malad, kindly sees they have annexed. Kindly comes to page 11 first.
Yes, page 11.
Yes, this is the CS records in respect of my ancestors.
11.
Page 11.
Documents.
That document that they have handed over.
Not any.
Yes.
Yes.
Kindly sees page 11 is the CS records.
Yes.
This is Malad Rayat,
Yes.
Nimai Bagh. Now kindly comes to their document, page 32 or page 27 first and thereafter 32. This is the handing over. Kindly sees the marked. Roshiv is at page 27. Page 11, thereafter 27 and 32. 27 and 32 are their documents. Page 27, kindly sees this is the plot number 4. It is marked. It appears that there has been highlighting, so therefore it has come up in Xerox. Kindly sees, here there will be a mark in the middle portion. Page 27.
Page
27.
Yes.
This is plot number 4.
4 is
Here it is marked. Kindly sees, like this in the middle part.
marking is such it cannot be.
Yes, it is 4. Let us proceed on the basis, I am also
Yes.
not disputing. And the area is 0.64.
Yes.
This has been. Now kindly compare that with the area of the area of plot number 4 in the schedule. That is at print. May I just say plot number 4 in the area is 1.57 acres. Their case is that they have been handed over 0.64 acres. Now kindly comes to their document, which they are relying upon. This is against me, but since I am showing, I should show. Next page, page 28.
Yes.
Dag number 4, Khairashal, Jongol, Bono Bibhag. This is my lord Khote number 1. And next is 164. That is also Bono Bibhag. Paschim Bongo Sarkar Pokkhe collector.
No, that is not Bono Bibhag.
This is Paschim Bongo Sarkar.
Yes.
One is Bono Bibhag, another is from
One is forest land.
Yes, has handed over this particular. They have diverted the land. That is the case that they are made out. They have annexed documents from to show that this land, the change of usage of land has been done. They have handed over, they have diverted the purposes, and they have handed over this particular plot of land to the defendant numbers 2 and 3 and 4. But while handing over, their document shows it is 0.64. My case is the land is 1.57.
Yes.
So therefore, there is a prima facie, my lord, discrepancy with regard to demarcation.
Not the entirety.
I am claiming 1.57.
Yes.
They are saying 0.6.
May I interrupt? This is hectares, that is, he is saying acres. 1 hectare is 2.471 acres. So 0.64 hectares is 1.58 acres.
Oh, yes, yes. This is hectares, that is acres.
Yes, yes. So any case, my lord, there is no demarcation with regard to, my lord. If the entire thing has been handed over,
Entire plot, there is no question of dispute of. I was thinking that it was a portion. Mr. Shoka has clarified. So it's the entirety. So there's your entire plot, and this, Mr. Lahiri, you can challenge this before the appropriate forum. Now it's
this
very
is challenge, my
difficult.
lord, that is what I am saying, my lord. Where is the linking document?
Linking document.
I would have understood that is Act 1. I would have understood
Forest land
Act, my
also,
lord.
it's a very difficult thing.
So it has
Cannot be.
It has to come to forest, and thereafter it has to be basically,
Yes.
it has to vest.
Yes.
The vesting proceedings can be done under
Challenge the vesting proceedings, Mr.
There has
Mr.
to be some
That
link,
cannot
my
be
lord.
by way of a suit, Mr. Lahiri. Prima facie, there is a vesting order. That cannot be by way of a suit.
Then until, my lord, I do something, my lord.
Mr. Lahiri, you have to do, because now
I was never given any notice.
maybe
As of today, it is in there in CS
Mr.
records.
Lahiri, even assuming that this vesting was not done in accordance with law, you have to challenge that. Challenge that in a manner known to law. That cannot be also done in a suit.
Yes,
Not
that is
challenging.
a different forum for that.
Yes. So prima facie, they have produced some document to show it has been vested. Now you have to, unless that order of vesting is set aside, it's very difficult.
By the time, my lord, everything will be done, my lord. There will be no land.
Mr. Lahiri, I started with my initial observations. If you succeed in proving everything goes, your property wrongly utilized,
My
you
lord,
are not
this is happening, my
nevertheless.
lord.
But
Rampantly,
this,
my lord, they just
because in the light of these documents, injunction cannot be granted merely on the basis of some recording in the CS record of rights. Because the subsequent, you know very well, the subsequent record of rights will prevail.
so that is the reasoning.
So
given.
that's the subsequent
That is the
record
reasoning
of
given.
rights. Subsequent, that's the well settled proposition that the
That is the reasoning.
later record of rights will prevail, and it has a presumptive value unless you can rebut that presumption. It's up to you to rebut the presumption. You have to take steps for that.
My lord, but kindly then, my lord, preserve, my lord, kindly make so many observations with regard to that, my lord, that I have a liberty or I have to.
Liberty is not necessary, Mr. Lahiri. You have
Kindly, my
very
lord,
well
carves out some kind of, my lord,
liberty.
exception so that, my lord, I can at least, my lord, proceed
You are
to
at
agitate,
liberty.
my lord.
Mr. Lahiri, you are liberty. No, you are at liberty to proceed in accordance, take steps in accordance with law.
By
I can
that time, my lord, if the status quo is not granted, my
Status
lord,
quo,
the
status quo in the light of these documents, status quo cannot be granted, Mr. Lahiri. Because if that is the public project and electricity supply, and you also know those line of decisions, then you have to compensate. You have to put in that security. That will be huge, Mr. Lahiri. Much more than your market price of that property itself. Because day-to-day loss.
we are, my lord, we cannot afford.
That is why. So those line of decisions are also there. In such a case, if injunction is granted, you have to secure that amount. Loss you have to secure. Because ultimately, after that, if your injunction gets dismissed, because you have to compensate them.
But kindly comes to, my lord, the
What is
reasoning of the.
Yes, show me the reasoning of the appellate courts.
Yes. Paragraph 30.
30.
May I just. Paragraph 29 onwards. Paragraph 29 is the current record of rights reasoning.
This vesting was in under the Land Reforms Act.
No documents to substantiate that.
Mr. Lahiri, you must be knowing. Record of rights, it appears you are not in,
And even if
not
it is,
deciding there.
even if it is Act 1, subsequently it
What
will-
Act 1?
even if it is,
Land Reforms Act vesting, not Act 1.
they have not said so. That is what my contention is, that they should say
Mr.
that
Lahiri,
these are
from the
vested
record
under
of
the
rights,
provisions. I would have understood. I would have gone
from the
through that.
record of rights, it is evident. That is why I told them. It's under the Land Reforms Act. It's under the Land Reforms Act, and jungle cannot be the owner of the jungle.
Well, these are
And
tribal lands.
in the yes record of rights also, the classification is jungle.
Yes, that is what I'm saying, my lord.
Yes, that is
so
why.
therefore, these are tribal lands which were there from my lord ages. Now, my lord, the coal company comes and my lord,
It has
everything is
vested
done
long
without.
before. Mr. Lahiri, your clients were not vigilant. Your clients were not vigilant. Now, when once this mining activity started,
yes,
you have filed that suit.
Process is that I will
You
be
have filed
served
that
the
suit.
notice.
So this can be understood.
Process
So,
would be I will be served the notice.
vesting took place long before. Record of rights, what you are doing? There is a detailed procedure in the for recording in the record of rights, starting from Khanapuri Bujirat.
Yes, at Kanakuli Gujarat also,
Yes.
there my name should be there.
Yes. So what did you? So you must be knowing from that. Some steps is going to be done.
That is my contention. They should have shown some documents.
It's you, Mr. Lahiri.
I would have understood. They have given the case number. Then
Before-
also it would have been
Before
done.
preparation of any record of rights, this local inquiry is being made. So you must be present to say something. Where is that? Then you must be knowing at that point of time, you would have
I might not
challenged-
be there. I might not be there.
Yes,
My ancestral
yes.
land, my lord, no notice. My contention is no notice has been.
That's understandable. You are not there. So if you were there, you ought to have challenged at that point of time, because it would have come to your notice at that particular point of time. Now, once these activities have started, because this activity started from 2019, and when have you filed the suit? 2023. So after really the operation started.
Yes, that is the case made out in the plate. If I go to that, my lord, if I go to that forum, it may be said that this is, you find out, fight out your, you fight out your.
Cannot be, Mr. Like. Coming after 5 minutes.
The petitioner, I am for the defendant petitioner. To have challenged the initiation of this proceeding under the Provincial Insolvency Act. Is it there?
Repeal statute.
Repeal statute. And Lordship, I find
You take that point before the.
this was the first time I was.
Appear there. I am giving you liberty.
I advised the client initially this one, but I found out from the records, it is the 50th number of proceeding that's being filed before the court. 50 insolvency proceeding, and this is happening day and every day. There is a racket going on. Because some people, they are obtaining certain details of people working with some organization with the central government. And when they are going to retire, they are obtaining details of when they are going to retire and all, preparing a promissory note, forging the document, filing a provincial insolvency, sometimes and the other obtaining an ex-parte order. And then the person concerned, most of them group D staffs, they are loitering around because not know where to go. Filing of this kind of proceedings needs to be stopped.
Yes, but you are retiring.
I'm retiring.
So that is why it will delay that. I give you liberty to file an appropriate application there. The
Number 14. Lordship, here I am the defendant petitioner in a suit.
same order.
No, it's a different matter.
Yes.
Suit for eviction and the plaintiff has stated in the plaint that he is a Tikka tenant. I took out an application under Order 711 that the suit is barred. That has been disallowed. I will be candid with the court that in the case that has been made out is that my mother, my grandmother, and thereafter my elder sister were tenants. And
you are the trespasser.
I am the trespasser.
Then
that is the case made out. But that is what I want to make some certain submission. That the learned court below has come to a finding that there has to be a finding made whether I am a Bharatiya or not. And the question whether I am a Bharatiya or not is covered under the controller under this Tikka Tenancy Act. And moreover, the defendants are mainly two in numbers, I and my elder brother. Initially, the case was that I and my elder brother both we reside in the premises as a trespasser, and after my elder brother passed away, the legal layers of my elder brothers have been made a party showing a separate address where they're residing. There is not the.
Can these be gone into under Order 7, Rule 11?
This is the defense case. But Shiv, I say that only submission that a preliminary issue be framed in this regard before the trial commences.
Not also a pure question of law. It's a mixed question of law and fact. Maintainability will be an issue. Have you filed your written statement?
I have filed my written statement. Taken.
So I'm directing the
because this has to be an
be
issue.
expedited.
Why I am concerned is that the question that whether I am this is kindly takes up the impugned order for once.
So you have raised the issue of maintainability of the suit
in the written statement as well.
Yes.
Kindly takes
So I'm
up.
directing that.
Kindly takes up the second last page.
Second last page of
the impugned order.
Of the impugned order, yes.
At the what is the page number 2?
Second last page.
The page number internal page number 2.
Yes.
That's actually the page number 2. It says that I'm reading from the last paragraph. So it is the duty of the court now to see whether the defendants are the Bharatiya under the plaintiff or the trespasser. Case is that he defines me as a trespasser, I say I'm a Bharatiya. And a question involved has to be decided by the controller under the Act. So I was urging on the point that the preliminary issue will be framed.
Tikka Tenancy Act. You have a copy of the Tikka Tenancy Act.
কি যশ সাহেবকে দিন
দেখতো ওটা
একটা বার করে দিয়েছিস which kindly takes up section 8. Section 8, the second point, subsection 2. Any question as to whether a person is a Bharatiya under a particular Tikka tenant or whether there is no Tikka tenant in a particular Tikka land shall be decided by the controller. And 21 says that anything that has to be decided by the controller is barred before a civil court.
So this issue whether you are a Tikka Bharatiya or not, that also has to be decided. Cannot be decided by the civil court.
Lordship. Otherwise, I wouldn't have preferred this revisional application because defense case cannot be considered. It's a settled proposition.
So you can file an application for framing of a preliminary issue. Otherwise, I have to direct you to serve a notice. That's
Let
difficult.
me, sir.
The petitioner, uh,
Stay.
nothing will happen. Issues framing, let it proceed. Yes, next.
My lord, item number 15, I am praying for not today, my lord. Because my lord, Mr. Sonjeev said is appearing, he is suffering from a fever.
On the prayer of the learned advocate for the petitioner, hearing of
The plaintiff is the petitioner before your lordship in a suit for eviction of trespass. In such a suit, my lord,
yes,
an application filed under section 151 praying for
yes,
praying for occupation charges to be paid, my lord, during pendency of the suit. Now, my
that
lord,
has been allowed.
that has been allowed, but admittedly, induction and the last paid occupation charge has been disclosed in the written statement. But the learned judge has granted, my lord, the current, not the area. That is, my lord, my application has been allowed. My lord, your lordship's judgment is now there. My lord, considering 2024 Supreme Court. My lord, this Khaitan consultancy, where your lordship has made a departure in respect of a suit initiated under section 6. But my lord, both these judgment, my lord, I have not. My lord. Vijay Kumar is been considered by your lordship, but in respect of suit initiated under section 6, your lordship distinguish it, that cannot be done. But here is a case, my induction, last paid rent, admitted by the defendant in the written statement. But the learned judge, my lord, directed the occupation charges to be paid, my lord, from the current date, not considering the earlier admitted areas.
This is a case of expiry of lease.
No, my lord, my case is of, he was a licensee, 11 months, up to 11 months, my lord, this was permitted, thereafter extended twice, thereafter I revoke, so he becomes a trespasser.
Nani printers is there, Mr. Mukherjee.
Sufferance. That
Nani printers, this type of limited extension, whether it can be said to be a license or a tenancy.
that is,
Achinta Kumar Shah versus Nani printers.
that will not, as on today, my induction and will not the what I say.
Induction, that's the judgment, that is the decision.
Even
Whether you caption it as a license agreement, if all the ingredients, so the agreements are to be taken into consideration. If the ingredients of tenancy, permanency, something is there, it has to be construed to be a tenancy, not a license. That's Achinta Kumar Shah versus Nani printers.
So that kindly consider here, even the Vijay Kumar case, the learned, the Honorable Supreme
That was
Court,
the case of expiry of lease.
yes, that, then also the last paid, it's about the
Expiry of lease and this tenancy, this stands on different footing.
this cannot, my case is of not of tenancy. If my case is of tenancy, my suit go. My suit will go. My kindly takes up the texture of my suit. I have annexed plaint. Page number 1770. I have been captioned him to be a trespasser.
No, does it depend only your framing of the suit or the materials which are to be in support thereof? Because Vijay Kumar was an admitted case of an expiry of lease. It was an admitted case of expiry of lease. Both the parties were on that. Only issue was that whether during the pendency of this suit this could be directed. But in a case of a monthly tenancy, let us suppose without paying for eviction under the Premises Tenancy Act, suit for eviction of a trespasser is filed. In such a case, if the agreement
ultimately, the agreement ultimately constitute, my suit will go.
That is one part. Your suit will go, that is one part. But can you fasten the liability on the other side?
Person, that's why I say the Vijay Kumar takes a consideration of a situation that a person here also, a person is economically exploiting the property and he is not paying off anything to the landlord. He may be tenants in sufferance, but he is enjoying a property, not paying anything. The regards is of section 6.
Because this judgment proceeds on the basis tenancy at sufferance.
Yes.
That is why I have taken note of that.
Because your lordship has taken a
cannot be a
departure.
tenancy at sufferance.
Your lordship has taken a departure because section 7 is there.
Yes.
So that will take care.
So
but in my suit
the
also,
very basis of Vijay Singh or Vijay Kumar, Manish Kumar is that such a tenancy is a tenancy at sufferance. But in a case where induction is by 11-month license renewed for 1 or 2 times, thereafter not renewed, can it be said to be a tenancy at sufferance? Because that is my, if it is not a tenancy at sufferance, whether you can get the benefit of Vijay Kumar, Manish Kumar. That's the test. Because if it is a case of monthly tenant,
my case is not of monthly tenants.
Mr.
Yes, your lordship.
I cannot make you.
No,
you have styled, you have treated him to be a trespasser. No difficulty in that. Vijay Kumar proceeds on an admitted case. It was a lease, expired. So admittedly, it's a case of tenancy at sufferance. But here, you have treated a person to be a trespasser, and he claims if it is by virtue of that document is a tenancy, whether this principle can be applied in that case, that's my query to you.
That's why I am taking a stand departure. If it is an admitted case of both the parties, that it is a suit initiated under section 6 of the Premises Tenancy Act, this the issue of the judgment will not be applicable at all. That's a different about the situation, my lord. Today I have brought a suit, my lord, under the conspectus treating him to be a trespasser since the license revoked. Tomorrow he comes and able to show before the court, demonstrate rather, that no, he is a premises tenant. The tenor of the language of the agreement between the parties ultimately construed to be, maybe it has been captioned as licensee, but ultimately concluded to be a tenant. Ultimately my suit will go, whatever the amount that he is paying, that is, my lord, for the enjoyment of the property. Think about a situation, my lord, even if it is not a case of mine that he is not a trespasser. His liability to pay to the landlord remain. That is something that your lordship is now balancing an equity. Your lordship is taking a departure under section 6 because section 7 is there to take care of all this default and all that. Section 14 is there in that case, but the Honorable Supreme Court has made it clear that even if sufferance you do not take 114, then also you have to pay. So here is also a case, even if he is paying, he is enjoying my property. I being a landlord, I cannot deprive a person commercially exploiting a property. I maybe captioned him as a trespasser. Ultimately, if I fail, then also his liability to pay.
Vijay Kumar, the amount was directed to be deposited in court. I think
yes.
That's the ratio of that judgment, and it was
subject
to the decision, not a final decision, pending SLP. Ultimately, in Vijay Kumar, Monish Kumar, Mr. Mukherjee, ultimate liability was not decided.
Yes.
So, Honorable Supreme Court, today, I think those are the concluding portion of that. So, final decision on that in a suit.
It's before the registry of the Honorable Supreme Court.
Yes, and it's subject to final decision. Please, yes. Paragraph 34. Please come to paragraph 34.
Yes, I am not paragraph.
Especially if petitions are pending adjudication, we make it clear that directions made in the above stated interlocutory applications herein are subject to the final outcome of the former, keeping in view the location, the alleged non-payment, the default, and such other factors. We are inclined to accept the calculation of the dues and so direct the respondent to deposit within 4 weeks affidavit of compliance. But here is the Supreme Court exercises that power. It's not a final decision which says, yes, in types of these cases, occupation charges are to be paid.
Milord, here, in the present case, they are not aggrieved. They are not aggrieved, Milord.
What?
They are, Milord, regarding the payment of this amount, apart from area, they have not aggrieved. What I, Lord, humbly beseeching before your lordship, while the learned judge is with me, with regard to the payment of this amount, they are not agreed. And when particularly the written statement, Milord, there is a categorical admission of last paid, Milord, amount.
No, I follow.
Why, Milord, this?
No,
Milord,
I follow your
I should
submission.
be deprived of this.
I follow your submission, but my query
yes,
to you is, there is this is not a ratio for the proposition that during the pendency of the suit, these occupation charges are to be levied. This not that proposition, subject to correction by you, has not been let down here in Vijay Kumar, because I have gone through this judgment in details, and though I have not gone to that extent because that was not required, I think I have
because your lordship,
that observation also that it was subject to the. I faintly recollect whether I have made that.
I have given your lordship's judgment also.
Yes, I think. Or I have left it at that because this was.
There are 2 coordinate bench decision of your lordship's court also in a case where the eviction of licensee is being prayed.
Oh yes, paragraph 30. After noting that an unchallenged market report forms part of the record, directed deposit of an amount with the registry of the Honorable Supreme Court to ensure complete justice. So this 142.
No, Milord,
ensure complete justice.
Here also,
intersect the parties. It was further clarified in the said order that the direction for deposit made in interlocutory applications are subject to the final outcome. So if it is other way around, he will get the benefit. So by this, Vijay Kumar, it was not finally decided that he will be entitled to that.
Because there, the Honorable Supreme Court is taking the amount to be a occupation charge, Milord, at the present market rate.
Identical case. That was the decision. Identical case. There also, it's pending. What happened to this SLP? This Vijay Kumar.
Vijay Kumar, subsequently, In the SCC online, I could not able to gather below anything after this.
Because this was directed to appear in July 2024. Because no final decision on this.
I believe, Milord, till today also there is nothing, no final decision, because otherwise in clicking
is
the SCC online.
What is binding, Mr. Mukherjee?
No, what today, Milord, I am seeking, Milord, if your Lordship takes up this judgment also, the coordinate bench of your Lordship's court. This is 2024 SCC online, Calcutta, page 7468. Milord, here both
is relying on Vijay Kumar.
No, Milord, it's 2024, but I believe by that time the Vijay Kumar was not there. Here 2018 1 CHN, the division bench of our High Court, Milord, wherein, Milord, the Connaught projects has been distinguished.
Where is the earlier? I think Connaught projects was considered here or not? In Vijay Kumar?
Vijay Kumar, Milord, Connaught projects, Milord, has been distinguished in 2018 itself by the special bench.
All right, you serve. Let them come. If they challenge this,
yes, Milord, there are grounds. I must be candid. There are grounds when I
Vijay Kumar is not a complete answer to this proposition.
But, Milord, in a case of licensee, there should have been, Milord, some decision also. Because this decision which I handed over.
One is during pendency of a suit. One is whether decision has been passed.
Decision, Milord, after decision.
This was the point, because that was the argument. So during pendency, it cannot be, because Attaram and others, those kind of decisions were considered there. So it says post decree.
Post decree, yes.
So now this is the question which comes pre-decree.
Pre-decree, yes.
What should happen? Here also conditional order has been passed, but no final adjudication.
No, Milord, cannot be done without final adjudication at
So
the
now,
stage.
now fastening a person now at this stage, whether it can be done merely on the basis of the plaintiff's assertion when the other side written statement has been filed. What is the case made out? Tenancy.
Tenants.
Then
no,
if it is a case of tenancy,
Milord, I bow down before your Lordship. Yes. If it is a case of tenancy, my suit is not eviction under section 6. So, Milord, his duty to pay rent, admitted arrear of rent, at least to the landlord, that remains. I say, Milord, this will rather not able to fasten him in future for any point of default if I can take, Milord, in a future suit. So ultimately, statutory
this will be a final argument if they challenge. If they challenge this order,
my quantum will reduce 500. Milord, I must be candid before your Lordship. The rent amount admitted.
Only that, Mr. Mukherjee, authority to charge occupation charges pending suit.
Milord, I
pending suit.
Milord, if it is a suit captioned as a licensee, and I could not even
make your arguments there. You can make your arguments there, but
law, that will be a
correction. Vijay Kumar may not be an answer.
No, Vijay Kumar may not be a direct answer.
Yes,
that's
till now, because issue has been decided there.
Our special bench 2018 said that in a pending suit like Premises Tenancy Act, this will not govern. Connaught projects as a distinguished
Act, yes.
But thereafter in 2023, two judgment came, Milord, from the coordinate bench of your Lordship's court, where again a departure is being made in a suit like trespasser and license. Say their liability to pay or deposit, that remains.
Relying upon any decision of the Supreme Court?
This judgment, no. Not. I say, Milord, trespasser or rather licensee has not been, Milord, able, Milord, till now not being answered. Because the case in hand before the Honorable Supreme Court, either tenancy or sufferance 106 notice. But in a case of a licensee,
I think it's better I'm affirming this. Go there, test it.
No,
there with regard to
Milord, I shall serve and come back. Only to
let that this point be decided. I'm framing the question. I'm answering that.
No, Milord, your Lordship's coordinate bench decisions are there.
Not considering any Supreme Court decision.
Considering our Honorable High Court's judgment.
Division bench. Division bench. But that division bench relies upon a Supreme Court judgment. I think not that division bench. I think that's a single bench relying upon the
single bench.
Justice Mukherjee's judgment.
Yes.
Relying upon that's a single bench judgment relying upon a Supreme Court. Relying upon a Supreme Court, that's the first decision on during pendency of the suit.
Thereafter,
Occupation
it has been
charges,
referred to the larger
but facts there are slightly a different thing in the Supreme Court judgment. Subject to correction by you.
No, Milord,
This-
that's there. But Supreme Court is now thinking on a angle that why the landlord should be deprived.
Thinking not yet decided.
Not the reasoning was that, but in a suit under section 106. The reasoning was that why the landlord will deprive. Ultimately, he has let out the property for gaining something, and you are enjoying his property.
This by the order impugned. Yes, November exhausted. Up to. That is what I was given impression that up to November cannot.
I am for the defendant petitioner in a
Yes.
suit for eviction regarding only calculation of interest. Although the
Calculation
learned
of interest.
judge passed the order for simple interest along with 10%, but he has calculated on compound basis.
Compound basis.
That is the only case. We made an application under 152. But he says if you are prejudiced by this calculation, then you are go to upper forum. An initial order kindly sees. And I am told by Mr. Mukherjee that one calculation chart is also there in respect of Justice Bhattacharya's judgment.
Mr. Bhattacharya has passed a judgment that's old annotated book, not this.
Mr. Mukherjee, that is under 56 Act. Interest under 56 Act and 1997 Act is different. That calculation, that formula will not apply here.
Regarding compoundness.
56 Act, do you have a copy of the 56 Act? 56 Act and 1997 Act, interest language is different. Find it out from your gadgets. You have those gadgets. West Bengal Premises Tenancy Act 1956. 8.33%, I think, per annum is the language in. Yes, Mr. Rai. What's the language in 1956 Act? 8.33% per annum. Per annum. Here it's not that.
Simple interest.
Simple. It cannot be compound.
That formula will not apply, Mr. That is in the backside of Ain Shah's book. Backside only in that book, Ain Shah's book, but that formula will
the calculation. If we can, Milord, just delete the earlier rate of interest and
No,
put it is
no. Language is different, Mr. Mukherjee. Where is 56 Act? 56 Act नहीं है कने. 56 Act. 1956 Act টা অনিয়ে Now it's only 10% of that amount.
Yes. And we have
I
calculated.
think there is a judgment delivered by Justice Tandon on this.
And I have got one judgment of Justice Sarkar regarding simple interest, no, without calculation, but judgment is to that effect.
How it is to be calculated? Show me.
It has not been, it says only simple interest, no compounded. This is a judgment passed by Justice Sarkar holding that interest of 10% only in respect of simple interest, not on compound basis. So my learned judge calculated in compound basis.
Have you got that? Yes. What's the language in section 17?
May I read 17.1?
Yes.
On a suit or proceeding being instituted by the.
You don't have to read that last portion. Interest at the rate of, together with interest at the rate of.
Together interest on such amount calculated on the rate of 8 and 1/3% per annum.
Yes.
From the date when any such amount was payable up to the date of deposit.
By the order impugned. Now, petitioner is 500. You are applying 10% of the total amount. That cannot be.
That cannot be. From 90 months, what simple.
That's your application. I do not know where from you have incorporated this calculation here.
We're
Yes,
taking
they-
recourse of old.
The plaintiff is the petitioner in a suit for eviction. My lord, suit decreed, my lord, in 2017, appeal preferred.
Expeditious hearing.
Order 6 Rule 17 in appeal court. My lord, that is, my lord.
Order 6 Rule 17 in appeal court. What do you want?
My lord, kindly direct that to be disposed of on, my lord, within a month. Because, my lord, what I need to brought into record is, my lord, the death of the original tenant and the death of the widow as well. So therefore, my lord, the heirs are no more have any right. So that amendment was preferred in appeal court. Now that is being, my lord, kept pending. If my lord sees it was filed in, my lord, August 2025. February
Fixed on 22nd of August 2025.
Yes, kindly direct that to be
This
disposed of
application
on
under
that.
Article 227 of the Constitution.
For the petition of plaintiff. The present revisional application is against the order for dismiss the suit or for non-compliance of the court's order.
Then suit dismissed. How revision is maintainable?
It's a dismiss for non-compliance of the.
What is the non-compliance?
The case of the case that plaintiff filed a suit for declaration, and that was decreed in favor of the plaintiffs. Thereafter, the respondent opposite parties has preferred an appeal. The appellate court has set aside the order and remanded back the suit to the trial court only for the portion to compare the LTI of the signatories by expert opinion. The petitioner, the plaintiff has filed an application for under order rule 30. Thereafter,
What is the order for which non-compliance of which it was dismissed? Where is that order?
that order 13 application to
Where is that order? Show me that order.
the impugned order, Lordship.
Not the impugned order. Non-compliance of which order this suit was dismissed?
Oh, non-compliance.
Yes.
That page 104.
104.
That's from 103, order number 93.
You are directed to take steps.
Directed to take steps. Admitted documents has been reached to the court, and then the petitioner has to call for the report and the documents that has to be compared with the admitted documents. The petitioner thereafter, the opposite party has preferred an revisional application challenging that order before this Honorable High Court. That revisional application is pending till date. And that on that notion, the plaintiff did not take any steps in the trial.
By the order impugned, the suit
my lord.
Yes.
The my lord, opposite party filed a title suit with a prayer for declaration and injunction in respect of a common passage. And the WS has been filed, WS by your reading statement has been filed by the petitioner. Petitioner is the defendant. And the evidence of the PW1 was completed at that time.
Where is the amendment application?
Your lordship kindly see.
This is the amendment of the counterclaim.
Counterclaim.
Where is the counterclaim? Show me the counterclaim and the amendment,
Yes, yes.
amendment application.
But annexure P3, annexure C, annexure P3, sorry. I beg your pardon. Annexure P3 is at page 41.
Page 41.
Page
Yes.
41.
Yes. No, this is the amendment application. Where is the counterclaim?
Counterclaim. Counterclaim is the counterclaim at page, written statement by your counterclaim at annexure B at page 27. Page 27.
Your evidence has been completed.
No, only evidence of PW1 was completed. It appears from the order dated, you will also kindly see the order dated, my lord, 27 September 2023. Both sides filed Hajira PW is of PW1 is of cross-examined in part, and thereafter the 13th December 2023. A letter not raised, given 5 straight proposals circumcised. PW is cross-examined in full and discharged. Evidence was not
So the
completed.
suit relates to the passage only.
Passage only.
But the suit passage, schedule passage has been
An iron gate was fixed, installed by the plaintiff.
no, the suit passage has been described in the plaint.
My lord.
Has been described in the plaint.
My lord.
So in the counterclaim, what have you said with regard to this width? Show me that. Have you disputed this width and other things in the? Show me that you have disputed that. What is your specific stand with regard to the?
Well, I have stated, my lord. The defendant stated.
Where is that?
Page 31. At kindly, your lordship kindly come at page 31. Paragraph 25, subparagraph A. that the defendant's case, including the counterclaim, is under all that part and parcel of land measuring 10 Shatak, appearing Mojas, tail number 18, Yesa number 161, Khojan number 126, Doji number Sanjasaj under tag number 538, originally belongs to Abdul Jafar seized and possessed. Transfer the said, the procedure that the 21 with the aid of local holders, fixed up an iron gate on the passage.
Yes, Mr. Gupta, please kindly come to page 31, paragraph number C.
Paragraph C.
Yes.
Are entitled to recover the 5 feet wide stripe of land on the
Yes.
side.
So this is the passage according to you, 5 feet passage.
Passage.
So now you are trying to withdraw that, change that. Please now kindly come to page 42, point number 2. Now you are trying to change the width from 5 feet to 2 feet. Plaintiff has also stated 5 feet. You have also stated 5 feet in your counterclaim. Now you are trying to change this measurement.
No, I am seeking the amendment of the WS counterclaim. More or less 2 feet of land in width, the ward, and 6 feet in length would be added, and in the 7th line of the same paragraph, after the and the said 2 feet, the wards wide and 60 feet in length. But after filing this counterclaim, the commissioner was appointed, advocate commissioner.
Yes.
And he filed a survey report. He filed his report.
Where is the commissioner's report?
My lord, I have not annexed the report, my lord.
But that might be an evidence, piece of evidence. So on the basis of the evidence, you will amend your pleading. When it's a specific, your case was, it's 5 feet width, and that tallies with the plaintiff's case of 5 feet width. Now you are trying to amend that by saying its width is 2 feet.
As per report, investigation report, that I see.
Is it the law that on the basis of the evidence you will amend your pleadings, or it's the other way around? You have to prove your pleadings by way of evidence.
I submit, my lord. If the written statement be allowed to amend, in that event, the nature and character of the suit.
This is not your written statement, sir. Counterclaim is a plaint.
Yes.
You are not amending your written statement. It's a plaint. So where is the explanation with regard to the proviso? Nothing. Why at this stage? You have not stated anything.
No, my lord. See, my lord, your lordship, kindly see, my lord. Kindly see when the evidence of PW1 is completed.
Sir, proviso steps in. Proviso, no satisfaction, nothing. You have not given any reason. Proviso, you have not given anything. This application under Article 2
21.
My lord, I am praying for not today, appearing on behalf of Mr. Dasgupta,
Which Mr. Dasgupta?
Saurajit Dasgupta.
On the prayer of the learned advocate for the petitioner hearing.
Number 22. Well, 22, my lord, I am for the petition. My lord, there is a caveat. But my learned advocate on record, my lord, could not able to contact with the learned advocate. That is why my lord, copy has not been served. And I have only obtained the name of the caveator. One Ramji. And
Yes, what is the order under challenge?
the order and the challenge, you know, against the demolition case. I am one of the co-owner of the premises. A demolition case has not been against my client, some other client. But ultimately, I came to know that the demolition order has been passed by the special officer building. I filed a BT appeal. And BT appeal was dismissed. Against that
Appeal has been dismissed.
Yes, that is why, my lord, I have come up before your lordship.
What is the infirmity in the order? Where is the demolition order? Where is the order of demolition?
My lord, your lordship, kindly see the annexure P4. Annexure P4, page 45.
Page 40?
45. Annexure P4.
Yes.
A demolition case was started against one Mohammad Mohiuddin and Tanvir Alam.
Yes.
My client is, my lord, Saira Khatu.
Entire building to be demolished?
Yes.
Without
I am
any
one of the
sanction?
co-owner.
Without any sanction plan?
That is their case.
Yes, show me the sanction plan. You are the co-owner, Mr. Chatterjee. End of the matter. Show me the sanction plan. You are the co-owner. So you must be having the copy of the sanction plan.
You give some, your lordship, kindly give some time, or I shall produce, my lord, whether the sanction plan or not. Well, or demolition order is page 46.
G+4. Stop work notice was also issued.
But in demolition case, my
Without
client
any
was
sanction
not at
plan.
all party.
Without any sanction plan.
And your lordship, kindly consent this. In demolition case, my client was not at all party. Ultimately, I came to know.
All right.
Demolition case,
Mr. Chatterjee, I appreciate everything. Show me the sanction plan.
well, at the right now, I am not able to show it.
Tomorrow, I am keeping it. Produce the sanction plan.
But instead of tomorrow, can it be day after tomorrow? Day after tomorrow.
Produce the sanction plan. So end of the matter. If you can show
That's right. That's
that its construction was made in accordance with the sanction plan. Yes,
That's
otherwise it has to be pulled down. Otherwise it has to be pulled down.
Only my grievance is, my lord, they did not make party to my client.
I am hearing you. That is why.
Very well,
Mr. Chatterjee, what you would have produced? So you are affected because you did not get any opportunity of hearing.
Yes.
So in the hearing, you would produce some documents in support of the construction. That is what I am allowing you to produce the documents in support of the construction to show that it's an authorized construction. And you are the co-owner, so you must be having documents in your support. The In course of this, they
As you-
also have to get an opportunity.
KMC as well as the caveat. KMC as well as the caveat.
Yes, and produce all documents in support of that construction. Yes, the construction has been completed or it's in the process?
Completed. So what by the instruction?
How long back?
That I cannot say.
Yes, next.
G for
Item number 23.
Good.
The petition of plaintiff, my lord, this is my eviction suit, my lord. What has happened on 25th of September, I was not present in court, my lord. The cost has been imposed upon the plaintiff, my lord, 5,000 rupees. Thereafter, I filed a recalling application that was dismissed and the cost of further 1,000 rupees has been given. Now, why I was not on 25th September, I have completely indicated in my recalling application. My father-in-law, who was the practicing advocate in the Calcutta High Court, was suffering from kidney stone. His report was going on 24th September. I have given the report date.
Previously also you paid for various adjournments.
No, my lord, kindly see previous date order. I have annexed that so that my lord, on page number 17, I will show first. Page number 17, the matter was first transferred to this bench, second bench.
What happened on 3rd of April 2025?
3rd of April.
Yes, that was the date fixed for payment of cost and for.
And I paid for time for filing this revision, my lord. But thereafter, the last order also records that because they are not letting me move the order 39 rule 7 because without payment of cost.
But this order was passed on 25th of
September.
Thereafter
on 11th.
The next date was fixed on 3rd of April 2025 and you have applied for the certified copy on 14th of July 2025. This shows that you are trying to delay the proceedings.
But on 25th September 2024, the next date was 18th November 2024. And on 18th November 2024, I filed the recalling application.
No.
Yes, my lord.
Please kindly come to the order date 11th of February. On 29th of September, date was on 18th of November 2024. On 11th of February, this order was passed directing you to deposit on 3rd of April 2025 and these two orders are under challenge.
I will kindly see the 11th of February 2025, the defendant has submitted, defendant has submitted
February order. You have applied for the certified copy on July. Why shall I not dismiss this on the ground of delay?
I will only see the records, but my wife was also suffering from
conduct. Your conduct is very bad.
My lord, the certified copy takes time for. I have applied.
Sir, when have you applied for 14th of July? It took only 7 days and you took 5 months to apply, sir.
But I have tried to consider.
Sir, you are blaming the department. The department took only 7 days.
Yes, my only condition is that I tried to pray mercy before the learned judge, but the learned judge did not budge without after seeing the medical condition. My lord, kindly see the medical condition once.
Rightly, because you are trying to delay.
My lord, not delay. My lord, on 25th September, this order was passed. My lord, kindly see the previous day's order. Both parties were present. My lord, order 39 rule 7 was heard.
Show me the
Yes.
previous date's order. Sir, you are trying to delay the proceedings.
My page number 19. My page number 19.
But
the matter was transferred on May 2024. My lord, kindly see the previous orders. I have moved the order 39 rule 7, but no order was passed. I can show that order also.
Yes.
Before the learned chief bench.
Why did you wait for 5 months to apply for the certified copy of this?
But I had played for recalling. Recalling was dismissed thereafter.
Sir, after recalling was dismissed, recalling was dismissed on 11th of February.
There are total of 12
11th of February and you have applied in 14th of July. 5 months.
There are 12 suits in total. All the suits, order 39 rule 7 has been filed. This is one of the order. But I have moved the same before the same bench. This was ordered on 8th January 2025. I will kindly see the. But even the only one submission, but the respondent has also appeared before the recalling application. He has also given his consent that the defendant submits that due to medical condition of the learned advocate, the plaintiff and his family members, defendant sought for adjournment.
By the order impugned, the 24, yes. Yes.
Plaintiff is the petitioner before your lordship. My lord, this is a suit for permanent injunction, my lord, restraining the defendant from dispossessing the plaintiff.
What is the order under challenge?
My lord, temporary injunction, my lord, initially ad interim injunction was granted in my favor. Temporary injunction was granted in my favor. The learned lower appellate court, my lord, set aside the said order and my lord proceeded to decide that whether the petitioner is a Borgadar or not. And my lord, learned appellate court decided that I am not the Borgadar. But civil court jurisdiction has been ousted, my lord, from deciding whether the person is a my lord, Borgadar or not. That is to be decided by the authority concerned. My lord, without
which authority?
My lord, revenue also under section 21(3).
21(3). Civil court cannot decide this.
Civil court cannot decide this. And the lower appellate court has decided that I am not a Borgadar. And consequently vacated the set aside the order of injunction.
Show me that where is the plaint?
Page, my lord. Paragraph, page 13, my lord. Clear portion. Page 10 starts.
You are plaintiff.
I am for the plaintiff. Both the courts will held that I am in possession of the property in question, my lord, and my name has been recorded as a Borgadar in the my lord record of rights. This is an admitted fact.
This is an admitted fact. They are also not disputed.
Admitted fact, but I am in possession of the property in question. And
admitted fact that you are a Borgadar.
No, not I am. This is not admitted, but I am in possession of the property in question, and my name has been recorded as a Borgadar. That is an admitted fact.
Yes. Show me the appellate court's order. 31.
Page, my lord, inner page 11 of the impugned order.
Running to 31.
Yes, what is the wrong in the order of the appellate court? Appellate court has considered everything.
No, whether I am a Borgadar or not, that
has not been decided here.
That has not been decided.
Yes, cannot be decided.
Yes, no, learned trial court, learned lower appellate court held that I am not the Borgadar.
Where is that? Show me.
Yes, my lord. My lord, he has my lord, set out my lord, several grounds.
You are the family members of the landlord.
My lord, my lord.
Then, Mr. Haldar, how can you be a Borgadar?
But that is the question to be decided, my lord.
It's the admitted fact. Do not come within the definition of Borgadar. What will be decided, Mr. Haldar, on admitted facts? Facts are admitted, Mr. Haldar.
No, my lord, there is no. I am not admitted that I am the member of the. Well, there is no admission. Can you have a
This is
look
the
at-
finding.
No, that is
Show me that you are. This is the finding. Kindly come
I
to
am, my lord, disputing the, my lord, the identity of the defendant.
prima
because
facie. It appears that the plaintiffs are members of the family of the landlord.
I am disputing the identity of
Defendant
the
and as
defendant.
such, their long possession cannot be presumed to be the possession of a Borgadar.
My lord, kindly have a look at, my lord, page 18, my lord. 18 and 19.
Under whom you claim to be Borgadar? Under whom?
My lord, kindly have a look at page 18, my lord.
Under whom? Please show me your plaint case. Under whom? Come at 2 p.m. Under whom you are claiming to be a Borgadar and that you are not a relation, you do not have a relation between the landlord and yourself. It's blood relation. That's the prima facie finding of the appellate court. Finding of fact, Mr. Haldar.
But so far as the, my lord, Granite court below proceeded, my lord, to decide that I am not a Borgadar. But that this.
Mr. Haldar, if two things are there, it's not in dispute that you are the family member of a landlord. Can you be a Borgadar under the definition? Those who are excluded, if that is what is the decision? What will be decided? There's no dispute.
But my name
Court cannot decide a dispute, but if from the facts it's apparent that you are not a Borgadar.
But
What will be
but from the record shows that my name has been recorded.
Maybe.
Page 18, my lord.
Mr. Haldar, maybe the recording is there, but if you are a relative of the landlord,
But that is
come
to
at
be,
2
the ultimate decision is to be taken by the authority concerned.
They are directing the suit to be decided. Let the suit be decided. No injunction.
But I am in possession of the property in question for a long time, my lord.
You may be in possession. Protect your possession. Protect your possession. I can direct the suit to be decided expeditiously.
But without deciding whether I am a Borgadar or not, this is the question, my lord, that comes up for consideration for the
That will be referred to.
That is till that decision, till my lord, the decision.
Prima facie.
Till that
Prima
reference
facie,
comes.
Mr. Haldar, it has to be decided on prima facie case. Prima facie, it's the finding. It's not. Maybe you can succeed. After it is referred, it comes.
But till that time, my lord, today, my lord, I will be evicted. Then
Prima facie, please
as
come at
and
2
when,
p.m.
my lord, it will be decided.
Come at
Then I
2
will be
p.m.
restored back.
Come at 2 p.m.
application, my lord asked me to get the actual what happened there, my lord. For last 1 week, we were trying to get the certified copy, my lord. Yesterday, they took the requisition, but they said that after 10 days, come over, we will give you the requisition. After signing, after the collector signs that, my lord. And on 6th, my lord, the
Collector has not signed the order.
No, my lord. No, not signed. No, no. The requisition, they will place the requisition before the collector. The collector is not there. After 10, they have asked us to go after 10 days, then only they will the requisition. Thereafter, they will give the certified copy after the collector signs it. So it will take time.
What are you challenging now? How can you challenge? The order is not there then.
No, order has been signed, my lord. Order has been signed, and
where is the what copy? Is the server copy?
Yes, my lord, server copy. This is server.
Show me that.
My lord remembers this matter, my lord. It was matter that we went before the collector, and the SDM also, SDO was also a party to the proceeding, my lord. Thereafter, my lord injuncted, asked the collector to take the proceeding in a video conference. Much obliged, my lord. Grateful, man.
Yes.
So far as the relationship is concerned, my lord, that is to be decided by the authority concerned, Bhaktas officer. If you're looking at under chapter 3, my lord, which chapter 3, my lord, falls, my lord, the section up to section 15 to section 21. Herein also, my lord, the relationship that is to be decided by the, my lord, authority concerned. Your lordship will find, my lord, in at page 9.
Give me a minute. Yes.
On the basis of my Borgadar scheme, I filed the instant suit for permanent injunction. Admittedly, I am in possession of the property in question. Both the courts will held, the plaintiff is in possession of the property in question. Suit property stands recorded in the name of the plaintiff as a Borgadar. If your lordship kindly turns to page 18,
18. Yes.
In the middle portion, Topon Gayan. Topon Gayan is my father. Page 18.
Yes.
In the
Topon Gayan.
middle portion, Topon Gayan. Topon Gayan is my father.
Yes.
And in the next page also, my lord. In the middle portion, my lord. Three ducks, 3 plots of land, my lord.
Plots of land.
Yes, my lord. 3 plots of land, my lord. One is 890, 898, and 910. 901.
890, 898, and
901.
901. Yes.
These are the 3 plots, my lord. This is the suit property, my lord, that has been recorded as a 1956 hon hoite, my lord, Borga recording. Next page also, my lord, 1965. One is 56, another is 65. Page 19. But this recording, my lord, has not been denied, my lord. This has been, my lord, rather, my lord, admitted.
Yes.
And my lord, in the defendant, my lord, in the defense case, my lord, has stated, my lord, he allowed the, my lord, plaintiff, my lord, to cultivate the suit land.
Yes. What is their defense case?
Their case is that, my lord, I am the, my lord, in relationship, my lord, with him, so I cannot claim, my lord, any Borgadarship. But I have, my lord, denied the identity of the defendant. I am claiming, my lord, Borgadarship under, my lord, Shivani Joddhar. Whether, my lord, the present defendant is the legal heirs of the Shivani Joddhar, my lord, now without any trial, my lord, at this, my lord, stage, my lord, court cannot, my lord, decide, my lord, that he is the, my lord, the owner, he is the, my lord, the legal heirs of the Shivani Joddhar. And, my lord, so far as the relationship is concerned, my lord. And, my lord, largest court below, my lord, proceeded, my lord, to decide, my lord, that I am not the Borgadar. Though, my lord, the property, my lord, recorded in my name as a Borgadar, my lord, page 9 onwards, inner page 9 onwards, paragraph number 15. Paragraph number 50, admittedly, the plaintiffs are in possession over the suit property. Now, can they be presumed to be Borgadar for such long possession? The answer is negative because of the following. Now, my lord, the learned court below, my lord, proceeded, my lord, to decide, my lord, the Borgadar right of the present petitioner. My lord, as is done by the, my lord, the Bhakchas officer. The learned court below proceeded in that fashion and ultimately, my lord, held that, my lord, no, I am not the Borgadar. This cannot be, my lord, done by the learned court below. The dispute cropped up for consideration before the learned court below, my lord, whether I am a Borgadar or not. I am claiming I am a Borgadar. The defendant is claiming, my lord, I am not the Borgadar. Now, my lord, the authority is the, my lord, the under the statute, my lord, is to decide, my lord, whether I am a Borgadar or not. My lord, admittedly, I am in possession of the property in question. My lord, at this time, my lord, so far the reference is made and the adjudication is done by the concerned officer. My lord, at this stage, my lord, for the preservation of the property in question, my lord, the injunction is required to be granted, as is done by the learned, my lord, trial court. Well, again, to that effect, my lord, I have, my lord, the decision, my lord, till the decision, my lord, whether I am a Borgadar or not.
Yes.
Till that decision, my lord, civil court power, my lord, to grant injunction, my lord, cannot be, my lord, denied.
Yes. Show me. Reference?
That is, my lord, reported in, my lord, 1980, volume 1, CLJ, page 75.
Yes.
so long malo reference is made, malo the court, learned court will is the season of the matter, and court can malo grant injunction till the decision comes after reference. Just to show দিলাম বলছি। আরে জেরক্স কপি ছিল তো কোথায় গেল এটা? তুমি তো বেঁধে দিচ্ছ। আরে এখানে তো সব আমি ভুলে গেছি। কত বলো?
Yes. Yes.
Malo so far malo this malo reference is done and malo it is malo decided malo whether I am a Borgadar or not. Malo till that time malo to preserve the malo the property in question malo when the learned court both the courts will held malo I am in possession and my name has been recorded as a Borgadar malo at least all status quo to be maintained unless and until this is decided. And the relationship your lordship is this malo whether your lordship malo asking me, my lord, whether the relationship can be decided because there is a relationship. I am denying the relationship because, my lord, I am challenging the identity of the defendant. I am claiming Borgadarship under Shivani Jodhar. I am telling, my lord, that
Shivani Jodhar is no more now.
No more now, but his legal years, my lord, gone to the Bangladesh. I am claiming that identity of the defendant. So, my lord, unless and until this is decided.
Who are the heirs according to you? Under whom you are the Borgadars now?
Now, my lord, the
what is your case? After the death of Shivani Jodhar, you are the Borgadar under whom?
Their legal years has gone to Bangladesh.
So, you are Borgadar under whom? What is your case?
No, I have claimed my lord Borgadar.
Because you have filed the suit, Mr. Haldar.
I have.
So, under whom you are the Borgadar?
I have claimed my lord Borgadarship under Shivani Jodhar.
After her death.
After her death,
under whom?
I also, my lord, approached before the authority concerned, my lord, claiming that I am a Borgadar under Shivani Jodhar. My application is under section 20, PS 21.
Page 21.
21.
Yes.
So, my lord, unless the decisions, my lord, comes, my lord, and court, my lord, is not powerless, my lord, to grant an order of injunction. Because, my lord, court, my lord, is not in a position to decide, my lord, whether I am a Borgadar or not. And the learned appellate court below, my lord, proceeded to decide, to adjudicate that whether I am a Borgadar or not. That is not, my lord, permissible under the law. Once, my lord, the question comes up for consideration, my lord, whether I am a Borgadar or not, my lord, reference to be made to the learned Bhakchas officer. And till that time, my lord, to preserve the, my lord, the property in question, my lord, my A should be, my lord, recorded.
Yes, what is the other decision you want to cite?
Oh.
Yes, what is the citation?
So here, my lord, the
What is the citation?
79 1 CLJ, page 104.
79 1 CLJ 104.
104, my lord, here is also, my lord,
Paragraph.
my lord,
On what point?
On point one of it, relationship. Your lordship is telling the relationship, there is a relationship, but that cannot be decided. But the relationship is to be decided by the the authority concerned. In the annotation book, it is noted. 16 plus 16, my lord. Plus 16, my lord. Right hand side. Relationship under chapter 3. Chapter 3, my lord, deals with paragraph section 15 to 21.
Yes. 79(1) CLJ, which paragraph? Any paragraph of that judgment, which paragraph? Which paragraph? Which paragraph, Mr. Haldar?
From the annotation book, I got this.
Annotation book, you
Relation.
got this. Not. Yes, yes. What do you say?
I'm for the defendant.
Please use the microphone.
I'm the defendant. If my learned senior friend says that I'm not the legal heirs of the landlord, so why they make me party at first? And that has not reflected in the trial court judgment also. I think they took this point in this time now first. It is the first thing, and it is admitted fact that I'm the legal heirs of Juddar.
No, how do you say admitted? He's not admitting. How do you say admitted? He is not admitting. That may be your case, but he is not admitting. Don't say admitted case. Because he is disputing that.
Disputing that?
Yes. Don't say admitted case.
He is the brother of maternal uncle of Rina Rani Juddar. And Rina Rani Juddar.
That's your allegation. He is not accepting that.
And
that's your allegation.
That has not says before any trial court or anywhere, and that has not reflected in the trial court judgment also. And in the trial court judgment, it is clear that he is my brother related. He has a relation with me.
Trial court judgment also. Show me.
Miss. Inner page 9, para 14.
Inner page
9
of the appeal court's judgment. Yes.
Para 14.
Yes.
Learned advocate, the defendant, that plaintiff produced being the brother's son of Shivarani Joddar is not entitled to continue the cultivation of the land as Borgadar. It is pretend to mention that under the Amendment Act of WBLR Act, the list of the relatives of the landlord who would not be Borgadar have been removed. So this submission has no legs to stand. And it is the record of Rina Rani Joddar.
Yes, that has been annexed here.
And my
Rina Rani Joddar. Who is Rina Rani Joddar?
is the daughter of Shivani.
Shivani Jodhar. Oh, in his name it has been recorded.
Yes.
Where is the record of rights you have referred to, Mr.
Page 18, my lord, Shivani Jodhar.
Yes, this is the subsequent record of rights, Mr. Haldar.
My lord.
This is the subsequent record of rights. Yes, this is of 2023. Please give a copy to him. Do you have an extra copy?
No.
Yes.
Yes, my name has also been recorded as a Borgadar.
That is the different thing. You are saying that he is nobody, nothing, no relation. Name has been recorded in the record of rights.
Denying so far as my lord, their name is recorded, my lord.
As Rayat.
As a Rayat.
Yes. And Borgadar under that Rayat. And you are saying I do not know who is
But
he.
whether my lord, there is relationship of not, that is to be decided by the.
That is a different thing altogether. You are saying that they are nobody, they are not the heirs. I do not
That
know.
is my pleading in the plain, my lord.
That might be your pleading, but Topongan, so your father,
my father,
not you.
After the death of my father, I applied before the authority concerned, my lord, to record my name as a Borgadar.
Till
That
now
is
not
pending-
recorded.
No, that has been pending for
Yeah.
consideration.
Till now not recorded. So nothing to show that you are a recorded Borgadar after the death of your father, because there are many heirs, of your deceased father. So they have to elect. Then
Yes,
there is a procedure.
There is no dispute.
There is a procedure how
There is
one of the heirs are to be recorded.
There is no dispute among the heirs of the original Borgadar. Out of them, there are three legal heirs: wife, son, and daughter. Now, son approached to the authority concerned to record his name. There is no dispute. No other is objecting to that.
Yes. Ashun.
Disposal. That is, we are the defendant before the court below. and defendant file lordship application under order 39 rule 4, and the next date of hearing is lordship 12 December 2025.
December?
12 December 2025, lordship.
Is the next date fixed?
Next date fixed.
For what?
For hearing, lordship.
Order 39 rule 4.
Yes, lordship.
My lord, I am for the petitioner, my lord.
Yes, Mr.
My lord, the caveat has been lodged. My lord, I have served also notice upon the caveat. Yes, sir. Watch. My lord, here what has happened, my lord, the learned trial
What
court
is
will
the
reject
order
the
in field?
validity of this revision application.
Remedy, why?
The order under order 22 rule 10 is subject matter of challenge before this regional court.
My lord, what has happened, my lord? Yes, my lord, my learned friend is correct, my lord. What has happened, my lord, the same order.
Level order.
My lord, that is true, my lord. I am not disputing that. In the same order, the learned judge has allowed in one part under order 22 rule 4. In the same order, he has allowed order 22 rule 10.
Is it a case of devolution of interest during the pendency of the suit?
My lord, that has been filed, my lord. I have filed an application. I am the plaintiff. I have filed an application under order 22 rule 4 due to demise of the sole defendant, my lord. And my lord, another 2 persons, my lord, filed an application that during the lifetime of the defendant, he executed a deed of assignment, my lord, in favor of the, my lord, then, my lord, what has learned judge has done, my lord? In the same order, he has allowed this prayer and also allowed that prayer, my lord.
In the appeal, you can challenge both.
My lord, that cannot be done, my lord, because once, my lord, your lordship kindly consider, my lord, learned judge has to determine who is the actual heir, my lord, under order 22 rule 5, my lord. Yes, to apply.
Order 22, Rule 5, Mr. Gupta, you are right. If there is a dispute as to who are the legal heirs, that can be referred to under Order 22, Rule 5. Now, if it is the case that there has been a devolution of interest assignment during the pendency of the suit, it's
Well,
under
that I
Order
have also
22.
challenged by filing an objection, my lord. Your lordship kindly see the order.
Yes,
My lord,
show me the impugned
my lord, order dated 11/6/2025. My lord, what has happened, my lord, the order
11/6/2025.
11/6/2025, my lord.
Where is the impugned order?
My lord, that is the order, my lord, before your lordship.
Where have you annexed that? It's now very difficult
My
to
lord,
find
first
out
certificate
the
copy,
impugned
your
order.
lordship. My lord, your lordship kindly see certificate copy you have annexed.
Certified copy. After that, there are many petitions. It's very difficult.
My lord, what has happened? A bunch of certified copy has been applied in.
Fine.
Huh?
Yes.
The beginning.
বিগিনিং এ তো লাগাতে হয় যেটা এটা লাগাতে হয়, পরে আবার লাগানো হচ্ছে সার্টিফিকেট কপি।
Yes, yes.
Miller got it. Miller, 11th of 6, 2025. Ordering portion, I first ordering portion. That
Yes.
the application dated 15/5/2024 filed by the plaintiff is allowed. Plaintiff are directed to file revised plaint with the names of the substituted defendants in the place of the deceased defendant, Tushar Kanti Gupta.
You are the plaintiff.
I am the plaintiff.
So you are not agreed by this portion
By
of
this
the order.
order, I am not agreed.
Yes.
My lord, your lordship kindly see.
Next.
Next, my lord. Next page, my lord. Ordering portion.
Yes.
That the application dated 19/4/2000, that is their application under order 22 rule 10, my lord.
Yes.
So allowed on
Mr. Gupta,
contest.
yes, so you are agreed by this portion.
Yes.
First portion you are not agreed.
My lord, your lordship kindly
Second
see.
portion order
My lord,
22
there was a
rule 10.
direction, my lord. In my prayer has been allowed for amending the plaint. And
Your
in
prayer
this
has
prayer
been-
also allowed.
Your prayer has been
by-
allowed.
My
Mr.
lord,
Gupta, you cannot be agreed by that. Second part, if it is wrongly allowed, then you
appealable order, my lord, there is no doubt it is an appealable order. But I have invoked the supervisory jurisdiction, my lord. How the learned, my lord, your lordship, kindly excuse me, I am putting the question in, putting my
Yes.
question for how the learned court can, in one order, can allow the two different contradictory orders in one order, your lordship, kindly see, 11/6/2025. Without determining the question. And here also, he directed the plaintiff for amendment of the plaint. Well, your lordship, kindly see, plaintiff is directed to file a revised plaint. In the earlier portion, he also directed the plaintiff to amend the
Give me
revised
a
plaint.
minute, Mr. Gupta. Mr. Rai, opposite party number 2.
Yes.
Since I am not inclined to take up this matter on cause.
Releasing this matter, my lord.
Thank you for pointing out, Mr. Gupta, that part.
If I say something, my lord, that I want to avoid. So let us. Otherwise, I'll place that application under order to take the.
No, but
That is why
Mr. Gupta invited me to that portion. First, the name struck me. Thereafter, I. Yes, next.
Grateful, my lord.
Item number 27.
Yes.
Answer the opposite part.
Yes.
in a matrimonial suit, my lord, the counterclaim has been filed by the husband.
Who are you?
I am the wife. Wife filed a suit for restriction of
Whose
conjugal
suit?
rights.
Your suit.
Restriction of conjugal rights. In that suit, my lord, the husband filed an application, counterclaim
Counterclaim
for declaration of nullity under section 25. Now one can turn to the.
What is the impugned order?
Orders are relevant rejected. Counterclaim which has been filed by on what ground, whether the 25 has been satisfied or not. If your lordship is of the opinion that the cause of action has been mentioned, satisfies 25, then I am out of court. If I can satisfy your lordship, the grounds based on which the counterclaim has been filed is contrary to the public policy. I am going to that extent, my lord, this is public policy. Why, my lord, can you turn to the counterclaim once? Page 86.
Yes.
Marriage was solemnized on 28/5/2023.
Page 86, which paragraph?
Page 86, my lord. The counterclaim of the respondent valued at rupees 100.
Which paragraph?
Yes.
Yes, counterclaims I have got.
Yes, my lord.
Which paragraph?
Can you turn to paragraph 18?
Paragraph 18.
Yes.
Of the counterclaim.
Yes.
Yes.
I don't want to read out, my lord, because
Nice to
property.
Marble floor.
Lordship.
Why are you opposing that?
No, Lordship, this is the second time. On earlier occasion, same kind of
What is the suit for?
partition.
Partition suit.
Partition.
If you get that property, will get a property with marble floor. That will any to your benefit, allow that to be done. If you get that property, it will any to your benefit with marble floor. Your property, your portion is not with marble floor. Or you have also installed those.
No.
So you will get that.
That's why in the plaintiff is supposed to object this application, Lordship. Lordship, as because the status quo was confirmed and absolute by the learned court in the presence of both the parties, Lordship.
It will be amounting to modifying the order of status quo.
Lordship.
Nature and character will not be changed. Thank you.
Otherwise, Lordship.
This application under Article 227 of the Constitution.
I'm for the petitioner, my lord.
মামলাটার মধ্যে রেখে দেবো Mr. Rai and Mr. Yes, Mr. Das.
My lord, specific purpose of contract, the defendant filed an application for rejection of the plaint.
Defendant?
Application for rejection of the plaint. So order
Rejection of plaint.
Yes. Now, my lord, that is dismissed. The point is that, my lord,
Second revision application is Order 7 Rule 11.
yes, my lord. The point is that, my lord, the
Yes.
plaint case is that on the basis
What is
of
the ground under Order 7 Rule 11?
on the basis of oral agreement, my lord, the plaintiff filed an suit for specific performance of contract. 2006, he taken possession of the same. 2021, he get the money, at least get the money from the defendant. Now he claimed that on the basis of oral agreement, that he's got a right over the property and filed the suit for specific performance of contract, that is to execute a sale deed by the defendant. The defendant had an application on the point, my lord, that oral agreement has no value when the matter relating to immovable property. Section 17 of registration is very clear, categorically stated, my lord, the vested interest has been accrued over a person by virtue of any document that must be registered. Therefore, my lord, plaintiff is saying on the basis of oral agreement, I have got the possession. After 15 years, he is saying I have got the money and to execute the
specific relief একটা দিন তো।
I am laying upon my lord section 17 of the Registration Act.
No dispute with that fact. But I think there is some proviso. The specific relief act with
Section-
regard to an agreement for sale, for filing a suit for specific performance of contract.
Proviso 34, my lord.
Specific relief act টা কোথায়? রেজিস্ট্রেশন একটা একটু দেবেন তো।
Provided that an unregistered document affecting immovable
Thank you.
property and required by
Anything more?
this-
Unregistered document.
But my lord.
That's the distinction.
If
That's the distinction for filing the suit for specific performance. That's permissible. What's the finding of the court? That is the-
Yes, and justice, my lord, that it is two judgment has been relied upon, and according to the judgment, it is permissible.
Well
But my
settled.
point is, my lord, that
Well settled, section 17, it has to be a registered instrument.
But if
But
my
for the
lord,
purpose of filing a suit for specific performance,
but if vested interest,
unregistered.
but my lord, only point, if vested interest has been already accrued, I think, my lord, 49 provisions will not attract, subject to correction, my lord.
Yes, it will attract.
If
Show me a decision, it will
already-
not attract. Show me a decision.
Then my kindly keep it.
Nothing, nothing.
And one time, my lord. Yeah, ছিল এটা judgment টা ছিল ওখানে।
পাতলা বই নেই, সবই
Take it tomorrow, my lord. One judgment is there, I have seen.
What judgment? For on what point?
On that point, my lord, if somebody on the basis of an agreement taken possession of the property in the
What performance?
what performance?
For you to claim, not for specific performance.
That-
It's for you. If you want the defense of part performance to be taken, then it has to be registered. It's for you, not for the plaintiff. This application under Article 227 of the Constitution of India is
Sir, yesterday I come to know from the trial court from an adjournment petition that they have moved with this case today. So I want to contest this case. I need to get the copy to be served.
What is this?
Lordship had taken this up once earlier. Lordship may recall, Section 34 is filed. In that Section 34, final of the Arbitration and Conciliation Act, challenging an award. In that Section 34, which is filed within time, the opposite party argues it finally. Final arguments are made before court. However, thereafter there is change of quorum. So from one court to another court, the matter goes. Subsequently, after having put in the written notes of arguments and after having argued finally before one court, because it will now have to be taken up de novo, they apply for amendment. Now, this is well beyond 120 days. 90 days is the right.
According to you, the amendment also gives rise to...
The amendment gives rise to a fresh application under Section 34 because certain points which they had not taken and in elaboration not taken, they are taking now. So it's effectively second bite of the cherry. Impermissible. We brought two judgments. One of this honorable court says that 617S principles will be applicable also in Section 34 amendments and in Section 37 appeals arising out of Section
Banerjee, Order 6 Rule 17 principles applies. Amendment relates back to the date of filing of the
Yes, it
suit.
does. It does.
That is so.
But then the entry gate is closed by the proviso. Either way, I either get the advantage of the proviso or I get the
Banerjee, the Section 34 enables setting aside of an arbitral award on certain specified grounds
mentioned in the
indicated in Section 34. So, if an application is filed challenging an award, maybe for two grounds, other available ground is
available.
Also, yes, other grounds are also available. Can that not be inserted by way of an amendment?
If it is belated, if it is belated at the stage of arguments,
then Mr. Banerjee, Order 6 Rule 17 cannot be applied. Because there are two things. Once you say Order 6 Rule 17 applies,
back theory.
Then proviso is commencement of trial, only that embargo, nothing more than that.
Yes. So I will have to
because also Mr. Banerjee, suits also all suits have a specified period of limitation. So if you say so, no amendment can be allowed at any point of time.
Limitation, according to some judgments, limitation is one of the issues which the court will go into.
Yes.
There are some other judgments like Justice Sema's judgment which say everything needs to be kept open. Please decide at the final hearing. Here, however, there has been a complete turnaround from the original score of challenge. This I will
that
submit.
is a different thing. Whether that can be allowed or not on merits is one thing. But can it
been allowed?
It's
It's been allowed.
No. Whether it can be on merits is one thing. But can it be shut out on the ground of limitation?
That would be one of my submissions. The second submission would be even if not shut out on the ground of limitation, then it can be shut out on the grounds of waiver. Here you have specific points which you can take. The grounds are limited, as your lordship very rightly said. Section 34, the provisions are limited. And if you don't file any provision, you always say that it is opposed to the public policy of India. That's the residuary provision which draftsmen like me sometimes used at that relevant point of time. But the problem is this: once you have gone in,
settling, it's available, Mr. Banerjee.
Yes, my lord.
Now it's while settling, it is available.
It is available, but then I used to. So that's why I said now I don't, because while settling I strike them out. But the difficulty here is, so what happens is at that point of time when he is ready to make final arguments, he has not taken certain points consciously of the entire bouquet he could have taken. That has implications. There have been exchanges, mutually exclusive points, they have now been taken. Now the question is, if this is permissible today, then my lord, essentially it's really a new section 120, new section 34. Beyond 90, 90 is his right. Beyond that, 120 in 34 cases cannot happen, because unlike appeals where there is a provision of condonation of delay, here there is a limited condonation power of 30 days. Beyond that,
condonation, if we consider let us not consider this to be an appeal.
Yes, I can
Let us
understand.
consider to be a suit.
Yes, an original
Also-
proceeding.
Yes.
Suits
Also
also have
have
a
a
limitation
period
which
of
can't, yes,
limitation.
but still amendments can be filed later on. Be saying that it will date
Because
back.
theoretically, some suits may have a longer period.
Yes.
If you take into consideration the preemption application, it's in months. So according to you, theoretically, no amendment can be permissible.
Mine, my lord, my humble submission here in 34 is, in 34, if you permit someone to belatedly amend at the stage after he has completed his arguments, then
That's,
you will
that's
be.
a different thing altogether. But what you are trying to
Yes,
say,
fundamentally not permissible, may not be, maybe a too high pedestal to put. I would, because the Arbitration Act is a complete code and he has to act in terms of that complete code. Code means, according to the timelines also, my lords have now settled it. Section 29A, my lords have settled it. 34 also, my lords have settled it. That it is like a big clock. One has to follow the chimes of the clock when one is going forward. And in fact, my lord, this is one of the points, my lord, which had been taken up by a coordinate bench. Though, my lord, I have gone through it. The coordinate bench doesn't, in so many words, say that it is untouchable. So I cannot place my case that high. I have to tone it down and say that in this particular case, considering the materials present in the original application and the development made in the subsequent amendment, it is really trying to put back waived points.
according to you, it's really changing the
nature and character of the 34, which of the 34 creating and recreating a new 34. So that's one, changing the nature and character of the 34. Now, while doing that, what does one do in 34? The question of waiver would also come in. In suit, whether the question of waiver would come in of some reliefs missed or of some cause of action not pleaded is really bleak. Question, really, if you present a suit today, a plaint, that can come in later.
In other way, Mr. Banerjee, this is different from that of an amendment of pleadings in a sense, because this is really challenging an arbitral award on certain grounds.
So it's more like an amendment of memo of appeal.
Yes. So if it is rightly what you are saying, if it's it's amendment of a memorandum of appeal, so can you not add grounds subsequently, even under section 100, which says on substantial question of law.
At the final hearing, court can
Even at the final
frame,
hearing,
yes, court can
after
frame.
admission
Court can
also.
frame. But here is distinguishable.
Those are the questions. So if the grounds are available,
yes,
because you are really challenging an arbitral award on certain grounds. So if the grounds are available, if you can make it, why not allow such grounds?
Because of the fact that from this varies in its texture from an appeal. It varies in its texture from an appeal. You have an award.
Banerjee, can you not take a point of law? Can you not raise a point of law at the ultimate stage if the foundation is in the...
Here it's completely fact oriented.
Foundation is the arbitral award, Mr. Banerjee, nothing more than that. So it's the arbitral award which you are challenging. You may have taken in an appeal. Mr. Banerjee, do you really argue an appeal going by the grounds?
Even court doesn't hear an appeal going by the grounds.
So nobody. You also do not argue. So on the grounds of appeal,
under Order 41, Rule 33.
Yes.
So court can hear on points which have not been agitated.
If that is an acceptable ground, court can consider.
In an appeal under the Civil Procedure Code, there will be a ray of distinction with Section 34. What I was
Section 34, you cannot go beyond those. But if you can bring in within those, you cannot say each and every. If it is outside those clauses of Section 34, no, you cannot. But if you can bring in within those clauses.
And what if there are mixed questions of law and fact? What if they are mixed issues of law and fact?
Yes, because you have to come. If you can come within those parameters.
Yes, yes.
Even if not taken at the earlier point of time. Where is the bar? Absolute bar in.
These my lords will decide. These my lords will decide. This is an interesting point which my lords will decide. Here the CPC doesn't apply in terms. It is a separate code. Supreme Court and my lords have said that it's a separate code all throughout. It has certain ramifications. There are certain very nuanced grounds which one can take. These are grounds which include grounds which have to be established on mixed issues of law and fact. Yes. Now you have put them forward in your Section 34, not therefore taken other grounds which you have deemed to have been waived because of your argument of Section 34. That has gone forward.
Because it's that set aside only on that ground. I think that's the language. Can be set aside
only on those grounds.
So it's the ultimately court's power to set aside on those grounds.
On those grounds, which is
Being
available.
satisfied.
Yes.
You may take very many grounds.
But the court will ultimately filter and see whether it comes within ABCD. Yes.
So you may take very many grounds.
Now, while
that is the bar in
no, no,
taking
here in the amendment thing, kindly may not consider this. This is an issue which my lords can decide. He is here. If your lordship wants, your lordship can decide. Matter is coming up on in October. I am told again, November. If your
What
lordship
has been done? That has been allowed.
it has been allowed, kindly hear out and decide this. Whenever your lordship wants, your lordship can hear it out. Your lordship will perhaps not. Your lordship will perhaps not, my lord. I mean, thinking aloud, this may not be an inarguable question. This may be an arguable question, which I am putting forward today. That in the conspectus of a Section 34 application.
Where is the amendment application?
Yes.
All right. You give him a copy.
Yes. Let me give him a copy. Yeah.
When this matter is taken up for
for a stay today. Otherwise, beyond if it does, I'll be in some difficulty. Otherwise, I'll have to maybe pray for a short stay.
what stay?
Stay of further proceedings because the matter is there.
When is the next date? Please?
I'm told that it's in
November, sir.
It's in November. If they
November?
Sufficient
You
time
feel
is
you
there.
mention that.
Fair.
Yes. Next. All the next matter.
Item number 31.
My lord, for a brief while today, please permit me 5 seconds of digression. When I joined the court, Justice Bhaskar Bhattacharya used to sit in court number 24 or 25.
Yes.
For a brief while today, when the petitioner was arguing about that agreement for sale not being registered and still it can be looked for a brief while today with the speed with which my lord took up the point, opened it and showed him, I went back to those days for a few seconds. Went back to those days. Our golden days are not gone, my lord. They are still very much there.
Thank you, Mr. Banks. Thank you. Yes.
For the petitioner, my lord, may I seek it for a day's accommodation, my lord?
Hi.
Mr. Siddhartha Banerjee is appearing in this matter. Mr. Siddhartha Banerjee is appearing in this matter. He is not in the town today, my lord. I'm only seek for a day's accommodation.
On the prayer of the learned advocate for the petitioner, hearing of the civil division. Next.
Item number 32.
The petition, Mr. Gopal Ghosh is appearing in this matter. He was there a little while ago. So
What is the
asking for a short passover. In court number 3, just a while ago he left. Short passover.
Passover?
Monthly list. Number 33. 33. 33 days.
33, my lord, I am appearing for you.
Yes.
My lord, in this matter, my lord, petitioner, before your lordship filed a suit
for declaration and permanent injunction against the defendant number 1. He was the sole defendant at the time. And this, he did not file any, my lord.
Yes, what is the order you are challenging?
Order, my lord, I am challenging actually, my lord, defendant number 2, defendant number 1, my lord, did not contest the suit.
What is the order you are challenging?
That
26th of March.
My lord, that is
26th of March, the ad interim order of injunction was extended.
No, my lord. 20. I am challenging the order that is 26 March 2025, my lord.
Yes.
For
Ad interim order of injunction was extended.
No, my lord, that is not the plaintiff is hereby directed to fresh steps on upon defendant number 1.
Yes.
This is my point, my lord.
Yes.
Defendant number 1 did not contest this. It was fixed for ex-parte. Thereafter, my lord,
show me that it was fixed for ex-parte against defendant number 1.
That is at page number 48, my lord.
48.
48. Plaintiff represented Hajira and also gave the plaintiff in chief alongside documents with Christie. His tendered evidence is full and discharged as PW1 for evidence of PW2. Thereafter, my lord, the matter was hearing argument of the suit ex-parte. Then, my lord, subsequently, we came to know that defendant number 1 sold out the property.
Yes.
Sold out the property. Then, my lord, after knowing, my lord, the plaintiff made an application under Order 1, Rule 10(2) for adding the new purchaser as party, my lord. That is at page number 53, my lord. An application under Order 1, Rule 10 is allowed, my lord. And defendant number 2 was added as defendant number 2.
Yes.
Thereafter, my lord, he also notices were served. He did not appear, and matter was fixed against him ex-parte.
No, so initially the suit was directed to proceed ex-parte against the defendants. Thereafter, you have amended the plaint.
Yes.
So then you have to take steps.
No, for adding the
Ex-parte order stood vacated once you have amended your plaint, sir.
Yes.
So now you have to take steps.
Defendant number 2, my lord, all along did not appear, my lord.
Maybe. So you file an application before that. It's not defendant number 2, it's defendant number 1.
Defendant number 1.
Yes.
No, all along appeared, my lord. Defendant number, thereafter, my lord, it was also fixed ex-parte against the defendant number 2. But
thereafter, after the plaint was amended, it was not fixed for ex-parte. It was
not against the defendant number 1. My lord, 1, because this matter may
1030 for the petition.
Yes.
There was a caveat, my lord, we have served him, my lord. Even my lord, prior notice of hearing has also been served.
Yes.
1030.
Yes.
Yes, my lord. My lord, in this matter, my lord, on erroneous assumption of fact, my lord, my application under section 7(1) has been dismissed as my lord time bar. If your lordship kindly comes to the my lord impugned order once,
Yes.
my lord, if your lordship kindly goes to the bottom, my lord, it has been specifically stated that on perusal of case record, it appears that on 25/9/2023, the summon was served on the defendants, but none turned on from the side of the defendant as transpires from the order. For then 18/10/2023 and thereafter 20/12/2023. On that ground, my lords, it has been rejected that I have come after, my lords, long after service of summons. Now, my lords, if your lordship kindly sees.
When you appeared?
My lords, I appeared on, my lords, 18, my lords, kindly note, 18/3/2024. 18th of March 2024.
When the summons was served?
My lords, it has been said here that summons was served on long back in.
I'm asking you, show me when the summons was served.
Let's kindly see. My lord, this is the entire order sheet.
Yes.
Let's kindly comes to my lord, order number 5. Summons was received by one of the plaintiff, and thereafter, my lord, order number
Summons
6.
received by one of the plaintiff.
My lord, order number 5, my lord, 3/9/2022.
Typographic.
It appears from the postal AD that summons received by one of the plaintiff. So at this stage, plaintiff has a petition praying for permission to take first steps. Thereafter, my lord, order 6. My lord, now no such persons in this address. Belief report also failed, my lord. Could not trace the, my lord, defendant's room. Thereafter, my lord, order number 8. It also says, my lord, no such person in this address. And my lord, defendant rooms was unable to find by the, my lord, belief. And thereafter, my lord, substituted service of summons was, my lord, prayed for, and that was allowed. And that was allowed on finding, without any findings that I am intentionally avoiding service. That is order number 10, 12/5/2023. And thereafter, my lord, the court, my lord, the substituted service of summons was made. And thereafter, my lord, since I have not appeared, the case was fixed, my lord, ex-parte.
Yes.
Yes, my lord. Now, if your lordship kindly comes to my lord, page 33 of my application.
Page 33.
Yes.
Yes.
My lord, this is the information slip. My lord, I have specifically made that whether any ejectment suit has been filed or not. And my lord, the information given that as per filing register and CIS, ejectment suit number such and such has been filed and 24/2022 before the chief bench, and the same is pending before the learned second bench on 18/3/2024 for ex-parte hearing of the suit. So, my lord, thereafter, my lord, I appeared after filing application, that is at page 34. Since it is, my lord, fixed for ex-parte hearing, so, my lord, I prayed to file, my lord, written statement and for setting aside of the same. So, this is page 34 is my application. I have specifically said that summons was not served upon me personally. And thereafter, this application was, my lord, allowed. And the order is at, my lord, page 49.
49. Yes.
Today's fixed for ex-parte hearing, defendant received the copy of the amended plaint. Defendant files vakalatnama along with petition for vacating the ex-parte hearing on the grounds stated therein. No written objection has been filed by the, my lord, plaintiff, and that application has been allowed subject to payment of cost of 3,000. And thereafter, my lord, after appearing in 18th of March, my lord, I filed this application on, my lord, 9th of, my lord, April. If your lordship kindly comes to, my lord, page 50. A record is put up before me by put up petition filed by the defendant. Defendant files a petition for 7.2 along with, my lord, 7.1 of the WPT Act. copy not served, let it be kept with the record. So within 1 month of the date of appearance, I filed this application.
Within 1 month from the date of appearance?
Yes, if your lordship kindly see section 7.1 once.
Yes. Consistency act. Yes.
7.1b. Such payment or deposit shall be made within 1 month of the service of summon on the tenant, or where he appears in the suit without the summon being served upon him within 1 month of his appearance.
Yes.
This is it, Manoj. We have filed within 1 month of the date of appearance. That is required under section 7.1b. And that is substituted service of summons has been allowed on that date. Not the summons has been personally served upon me.
Summons has not been personally served upon you.
Yes, my lord.
So summons was served under Order 5, Rule 20.
Yes, my lord. Your lordship is, my lord, maybe, my lord, the proviso. Order 5. Order 5, Rule 20 proviso. Or the explanation clause, maybe.
Yes. What does proviso say?
No, my lord, there is no proviso. Sorry, my lord.
Yes.
My lord,
yes.
and my lord, one thing is that, my lord, Article 123 of the Limitation Act, it specifically says substituted service cannot be taken up as a due service, and it should be period of limitation should be counted from the date of knowledge. And there is one judgment, if I may.
Yes.
This is 2024 SCC online DL 497. Paragraph 2, this is a commercial suit, and written statement has been filed after 120 days. So, the written, the pair for, there is a forfeiture of of the right to file written statement, paragraph 2, and paragraph 15, if your lordship kindly counts.
Paragraph
15.
Yes.
— 15, 19, and 21.
So according to you, Article 123 shall be applicable.
Yes.
For what?
For my lord, that it should not be my lord, date.
123 applies for what?
My lord, first of all, these act itself says from the date of appearance, and even if from the
That
date
is
of
for
appearance,
setting aside ex-parte degree, sir. 123.
my lord, here this has been
Here
made
no,
applicable.
no ex-parte degree has been passed.
My lord, here it is made applicable. Here also no expiry decree has been passed. Here, my lord, it has been, my lord, written statement filed after 120 days has been, my lord, rejected because this is a commercial suit. That is why rejected. Court, my lord, made applicable the provision of, my lord, 123, although, my lord, says that 123 is not specifically applicable.
When you have got the copy of the plaint?
My lord, on that date, my lord, 18/3, my lord, of your lordship. My lord, if your lordship-
18/3.
Yes, my lord, if your lordship kindly sees the order, my lord.
This bunch of the order?
No, my lord, the annex to the petition 49.
Page 49. Yes.
2 days fixed for, my lord, ex-parte hearing. Defendant received the copy of the amended plaint.
On 18th of March.
Yes, my lord. And the very next order, my lord, page 50, 9/4/2024, within 1 month, 7172 has been filed.
Yes, what do you say?
In my humble submission, I shall start that I had filed the ejectment suit in the year 2022. Exhausting everything, it was seen that it is a typographical mistake which we didn't correct it, that it was served upon the defendant.
One of the defendants.
One of the defendant. It was the opinion of the judge. You serve it again. We serve it. Substituted service completed. They have waited all along. They were looking after the matter. Your lordship will kindly seize how they have got the information slip. What happens in lower court if you file information? First of all, it takes a lot of time. We file it, we search it, and then kindly comes to paragraph number 1. From paragraph number 2, my lord, I'm reading. It will show how they have acquired. Page 4. The petitioner thereafter immediately contacted.
Paragraph number?
Starts from paragraph 2. I'm reading.
Yes.
The defendant number 2 petitioner states that the summons of the said suit was never served upon the petitioner on 13/3/2024. The petitioner came to know from one of the tenants of the suit building that an eviction suit might have been filed against the petitioner in respect of the tenanted shop room. He's saying that he got information in 2024, whereas the substituted service was completed in the year 2023. Now, Your Lordship, the petitioner thereafter immediately contacted his learned advocate and instructed him to inquire about the same. Accordingly, an information slip was filed on 14/3/2024 to inquire whether any ejectment suit was filed against the petitioner or other defendants in respect of the tenanted shop room or not. Thereafter, on 15th, the very next day, 15/3/2000, the learned advocate for the petitioner obtained the information slip, wherefrom the petitioner came to know that the ejectment suit number 149 of 2022, the said information slip also revealed that the suit has been fixed for ex-parte hearing on 18/3/2020.
Shows that he was very vigilant.
Yes.
So 18th of March, ex-parte hearing. So he was very vigilant. 13th came to know, 14th applied, 15th got that, 18th he filed an application for vacating that.
33, if your lordship kindly comes.
Sir, you have made your submission.
In small closet court, my lord, I practice there. It takes around 1 week approximately to inquire if you want to. But if you have given specific date of the ejectment suit and everything, then my lord, it is very much possible that they will get it, my lord. That is what they waited for the entire. It is a ejectment suit of 2022. They waited all along when let the suit be fixed for ex-parte, then we will appear. That is the conduct they had followed, my lord. On that ground, my lord, substituted service is completed. In my submission, I have completed my service, my lord. They have not appeared and let the suit be proceeded ex-parte without giving them any opportunity.
No, but what is the submission with regard to that section 7(1) says 1 month from the date of appearance? What do you say to that?
My
Because
lord, in that case, there is summons how the it is
because
like
the plaint, the notification was that paper publication, but the copy of the plaint and it was amended. When this amendment took place?
there was no amendment, my lord.
Yes, because this order says the copy of the amended plaint was served. Why amendment? You show me that order. Which order?
My lord, page 49.
49 says copy of the amended plaint. Defendant received the copy of the amended plaint. Why amendment?
My lord, I have to take instructions, my lord. I'm not.
Because there the summons, the notice might have been published, but unless he gets a copy of the plaint, how can he file an application under section 7(1)? Because the default which you have alleged and other things that have to be taken into consideration while filing an application. So show me that the plaint was served upon them. And this is the copy of the amended plaint. It was received by them on 18th of March.
My lord, as instructions have been given, there is no amended plaint, my lord. I just need to inquire, my lord.
But this order record, yes, where is do you have the copy of the amended plaint?
I have no, my lord, because I have not.
Because there was no amendment, my lord, as far as from my.
My lord, the plaint I have got, my lord, I have annexed.
In the order it is written, my lord, but from my instruction there was no amended plaint. I don't have the earlier order, my lord. When there might be an application under order 6 rule 17. If that be so, there might have been an application. I don't have the entire order sheet, my lord. There might be an application under order 6 rule 17 if there was an amended plaint.
No, page 18 is the, my lord,
But,
amendment.
I think you have annexed the entire order sheet.
Yes, my lord.
Prior to that, that also does not show any amendment.
My lord, summons has not been personally served upon me, so plaint will not be served upon me.
Because they have avoided, my
No, no, no. That is a different thing altogether. But it says about the amended plaint. Where is the amended?
My lord, whatever plaint, my lord, I have been, my lord, served, I have, my lord, annexed.
Show me the impugned order. What
Yes,
does the
my lord.
impugned? Let's see.
Certified copy, my lord.
impugned order, my lord. The judge is holding substituted service and came to a finding that the summons have been served.
My lord, only consider that settle order 7172 within 1 month from the date of service of the summon. My lord, only consider that 1 month from the date of summons. That is only considered.
Yes,
Date of appearance has not
rightly
been
considered.
Yes, my lord.
Rightly considered. 1 month from the date of service of summons. If the summons is served and you wait for 6 months, then you say, I have appeared from this day and give me another 1 month time. Is it the law?
My lord, one thing is that, my lord, they are now saying that I am very vigilant that I have filed it on 30. I
No, no,
got the
they
information.
are not saying. I am saying.
No, my lord, they are
Looking
contention
at
is
that, your conduct, 13th you came to know from one of the tenants, 14th you applied, 15th you got the information slip, and 18th is the
No,
date
then-
fixed for
then
expiry
that
hearing.
might be forged.
You applied for
My lord, then that might
vacating the ex-parte hearing, but not the application under
very well,
section
my lord.
7.
Kindly come to my lord, page 33 once.
Yes.
This is the my lord information slip with the my lord sign and seal of the court. And my lord, he said,
Nobody is disputing that,
and my
sir.
lord, she said that the specific date has to be mentioned. Then only it can be my lord, we can get this at a my lord, within short span of time. But my lord, I have not mentioned any date. My lord, the application information I have required, my lord, it has been mentioned.
Yes, yes,
clearly.
when you have applied for information,
Yes,
getting
my
the
lord,
information,
my lord, it has been said in the receipt as is my lord,
Yes,
they
yes.
have received it on 14th.
Yes.
And my lord, they have given it on my lord, date on which the information is to be ready 15th March. They have given it on my lord 15th of March. It has been issued under the sign and seal of the court.
so it's very good that within 1 day these informations are given. So I will remember that because for taking
Malas-
informations, I will be giving
Malas-
only 1 day's time.
My lord, kindly consider that my lord, my defense will be struck off if this my lord on this court, my lord, and if it is the contention
Has to be struck off.
my lord, if it is the contention that my lord after expiry of my lord, I am all along vigilant, and my lord, after expiry, my lord, the suit was fixed for expiry hearing, I have applied. Then my lord, I should not have waited for 3 days. Should not have waited for my lord 6 months. I should have come within there on the date on which my lord it has been fixed on expiry hearing. I should have come on that date. I should not have waited.
Come on that date, sir. You have come on 18th.
Manoj,
You
I
have come on 18th.
and Manoj, and
So you had the intention to come on 18th. So for the purpose of supporting that, 2-3 days prior, you have obtained a information slip.
Manoj, and one thing is that Manoj, they have
Show
not
me your 7-2 application.
7 to application.
Yes.
Page 30, page 39, my lord.
Page 39.
Page 39.
This is a impugned order arises from 7-1. 7-2 is also disposed of holding the same order, my lord.
7-1, 7-2 has been also subsequently disposed.
Stopped receiving the rent from December 2001. 7-2. Sir, did you deposit the admitted arrears of rent?
7-1 has been Manoj,
7-2, I am asking you, did you deposit the admitted arrears of rent?
7-1 has been dismissed.
So am I asking you, you have filed this application under section 7-2?
7-1 and 7-2. 7-1 has been dismissed.
7-2, I am asking you, did you deposit the admitted arrears of rent? Paragraph 3, you have admitted this.
Manoj, 7-1, if it is not allowed, Manoj, I will not be able to submit the Manoj admitted area of rent because Manoj department will say no, there is no order.
My lord, 7-1.
Where is your application under section 7-1?
7-1, yes, Manoj.
Yes.
37.
7-1.
So 7-2, what have you disputed? 7-2, what have you disputed? What have you disputed in 7-2? Where is the dispute?
Manoj, the dispute specifically that is there if there is any default. Manoj, kindly, Manoj.
Thank you. This application under Article
7-1 has been Manoj dismissed. Manoj, 7-1, 7-2 has been subsequently dismissed.
1091. This matter was mentioned citing urgency. Considering the urgency pleaded, this matter
In this matter, I'm paying for the petitioner also. Also, I'm led by Mr. Mondul. I'm seeking adjournment also. I'm seeking adjournment, praying for time also.
except adjournment, submit other things. No
Also, in
adjournment,
this
sir.
matter, I'm led by Mr. Mondul Jana. Also, he is engaged in another court also.
Sir, please start. Please start.
Also, in this matter, I have no instructions sir, also.
Please start. Otherwise, it will go out of list.
So kindly note today also.
This matter was mentioned citing urgency. Considering the urgency pleaded, this matter was
On 6-4.
My lord, in this matter, I am for the opposite party, my lord. This matter has been appearing for last 2 months. I have already served notice. I don't see the.
You are for the opposite party.
Opposite party. I have preferred an application for vacating a prey. I'm suffering a stay in the eviction suit before the trial court, my lord. Now the matter is, my lord, that the revisionist has filed a partition suit in respect of
the interim order is still subsisting.
Yes, my lord.
Who is appearing for the
Mr. Shamanto?
You have served the notice.
Yeah,
Start
I've served the
mentioning.
notice. I've served
Show me that.
In 2 occasions, I have served, my lord.
This matter
Thank you. So I cannot lose twice. I have a declaring application from the order of DRT, my lord.
Who is for the petitioner? Mr. Chatterjee, have you served notice?
Yes, yes. Original notice টা mentioning এর কাছে আছে তারপরে দুবার notice serve করেছি
Many times it has been served.
What is the
DRT order. Section 14 from the order of DRT. So I can't lose twice. Before your lordship on the same.
227, Mr. Chatterjee, supervisory jurisdiction.
I can't lose twice. I have lost before.
Facts are different, Mr. Chatterjee. Facts are to be looked into.
Chani, you know, I have told people outside that I know this is going to happen. It's been happening traditionally. Cali vacates the interim order because the bank will not, otherwise they will never come.
Ashun, this matter was
ঠিক আছে।
Item number 1221.
For the petition.
Yes,
Led by Mr. Tanmay Mukherjee.
he's opposing you.
No, he is with me.
He fell asleep. Fell asleep.
Here, with the issues pending before the larger bench.
What is the issue?
That to be short consideration.
Short consideration also larger bench.
That would have been case of a non-notified co-sharer to the Justice Bhattacharya as referring.
That is
Non-notified co-sharer, what is the distinction between non-notified co-sharer, notified co-sharer, Borgadar, and adjoining owner with regard to short consideration, Mr. Mukherjee?
Justice Bhattacharya's view, the line of the Barashat Eye Hospital, that is the ratio decided in respect of a adjoining owner, not in respect of a short consideration.
That is why I'm asking you, what's the distinction in the accrual of right of preemption vis-a-vis these three categories or four categories which we can.
That is not the exact point what distinction has been drawn and the larger bench is being.
Sir, Mukherjee, pendency of a matter before the special bench is a bar in taking up.
Now it is not, and in one of the matters that your lordship can remember that I also appeared along with Mr. Banerjee, my lord has waited for this because this point has been shown before your lordship. Now the larger bench is being in consideration of this.
Larger bench is hearing.
Sure.
So Mukherjee, what's the distinction? Please, merely because that matter was in adjoining owner, that's neither here nor there.
Larger bench has now been constituted.
Maybe constituted.
That in personal opinion, yes, there are line of distinction whether it can be survived after Barashat Eye Hospital, that the initiation of proceeding by a preemptor in whatsoever ground, whether the prerequisite of section 8 has to be fulfilled.
So there are two things. There are different categories of persons who can apply for preemption. But the section 8 with regard to this deposit of consideration does not make any distinction.
Departmental way,
Nothing.
but Justice Bhattacharya will not in one way or the other have held this may be a weak right for with regard to the other section, that is the adjoining co-sharer and all that. But if it is a co-sharer, whether the short deposit can be said to be so fatal that the application itself will be not maintained.
Mr. Mukherjee, you may say it's a statutory right, not a weak right. So even if it is a statutory right, not a weak right,
then also prerequisite has to be fulfilled.
Then
also prerequisite.
So if you are on a statutory right, even worse. If you say it's not a weak right, it's a statutory right, maybe a weak right for adjoining owner, but a statutory right in respect of others, prerequisites of the statute are to be complied with.
Here, I applied for deposit of the rest, which has been turned down, and the court has fixed for.
Cannot be, because Supreme Court has said after the period of limitation, nothing. If you are a non-notified co-sharer, 1 year. So show me that if
that be so, my opening sentence will be other. That is not there. But in view of this, judicial decorum, your lordship keeps it so that.
But larger bench pendency does not bar, because I think in another matter it was decided. And you had the occasion to appear in that matter. So I have that ratio, show me that. So I can follow that also. Pendency of a matter before the larger bench cannot be a ground. Give me that. You had appeared, Mr. Chatterjee also appeared, Mr. Rai I think also appeared. Show me that judgment. I will follow that. Yes, so I will follow that. So pendency, Mr. Mukherjee, all matters cannot wait in this. Or of short consideration, nothing. Supreme Court has decided, after that, nothing. Show me that mere pendency of a issue before the larger bench cannot stop the court from deciding the matters. That's the Supreme Court is also saying that.
That 58 judgment which I have shown me in the other matter, preemption.
Which?
The 1958 Supreme Court which I have shown.
Yes.
I will kindly read that plot here also, in respect of entirety of the plot of land, the preemption application will be maintainable, that has been made down.
Statute is clear, Mr. Mukherjee. Statute is clear. The statute is clear, has to be. That is why,
It has been.
please give me that judgment. So, mere pendency of a matter before the larger. I know that. You need not bring, I am deciding this. Because you cannot dispute that.
But there are other judgment also, Lord. I will assist your lordship since your lordship is holding.
Because the Supreme Court is also saying, mere pendency of matter, you should not wait, please decide that. Even if the issue is pending before the Supreme Court. That's the recent decision.
Your lordship, so far as it is the other judgment of the court is concerned, only single aspect. That will help you. It's not that is not in my favor.
I'm aware that this, even after that, these matters are being decided.
Yes.
So I know that, and give me that decision. Also give me the decision of the Supreme Court which says pendency will not.
That decision will.
Really showing two special bench, two larger bench, or of thought consideration, Bastu, nothing.
My lord,
Could also state, Milord, with respect to this reference case, with respect to that, Milord, statement acceptance, when JJ Merchant and those decisions were not referred, not in the, I understand it's ONGC or something like that, but in that case, Supreme Court had stayed.
Yes,
And
that is,
said that.
so in some matters, it is being stayed. In other matters, it's saying where it is not stayed. Court should not keep these matters pending.
Depends on the outcome. Depends on the outcome.
Nothing.
Depends on the outcome.
After the Supreme Court has decided or and off,
The reference is of such a nature that if the outcome is decided.
Mr. Kormuka, these issues, once it has been decided by the Supreme Court, can the larger bench go beyond the Supreme Court decision? I fail to understand this.
No, Milord. But may I serve and come back so that Milord, your lordship will decide. I'm not asking for any interim relief. So that it
But-
can be decided that in one way or the other, Milord, your lordship is not waiting for this special bench. So it will be on merit. So if at their present, Milord, it can be. Because ultimately the preemption application which has.
It's your application.
It's my application. It's
Which will go. Let the other side not be disturbed at this point of time. But if I decide that it is to be.
Judge has Milord make it pending. Made it pending.
What made it?
By the order in
Why?
application has been dealt with and rejected, and the preemption application is still surviving.
How?
Yes, that's not.
That I will.
I'm just. So Milord,
That observation I will make it here.
that's
Now, after
Milord,
that,
may
nothing
serve and
remains.
come back so that Milord, since your lordship is deciding the issue and
Mr. Mukherjee, they will not be affected if it is dismissed because it's after all your preemption application.
it's my preemption.
So they will not be affected. If their right was affected, is hereby rejected and for temporary injunction application.
It's still pending.
Nothing remains. After this short consideration, everything goes. When?
Gives me 2 weeks, Milord, I shall
2 weeks.
hand over to your lordship all the judgments. Only that. Thereafter your lordship will decide. All the judgment, Milord, including the
All the judgments with you. It will take 2 weeks. And in most of the matters you appeared. Most of the matters you appeared. And I have followed that decision also. In another matter, larger bench, I have not accepted. I have said, yes, pendency of a matter before the larger bench. Yes. And I have followed that in another matter. That issue, I think maybe in this short consideration, I have followed that decision. That it
Pastu did not wait. In one of my matter, I argued that the court should not wait after this Supreme Court judgment. Abdullah. After the Supreme Court judgment, I argued before this honorable court that the short consideration which has been cured by
Not on short consideration on the injunction matter.
injunction matter, yes.
Mr. Chatterjee,
Yes, yes.
Mr. Chatterjee appeared. He was the architect in that judge.
Yes, strategy was leading.
Yes, next. এটা order record করুন. Heard Mr. Mukherjee.
Get for the opposite button. Alright, it is the matter where the appellate court refused to stay of an order granting police help on the ground that there is a Section 5 application is pending. Alright, I am the judgment debtor. I lost in 3 courts.
Lali stores, Leela stores.
Lali stores, Leela stores.
That one must decide with this matter correction of decree.
Correction of decree. That police help allowed.
Now what happened?
I preferred an appeal. Wrongly, I preferred a means appeal. I obtained a stay. Expert identity order of stay. A respondent appeared and raised that issue that order passed under order 20.
Why title appeal? Why title appeal? Why title appeal?
Latter, because under order 21 rule 103, the order passed under order 21 rule 97 is an appeal is a deemed degree, and therefore the title appeal lies. Therefore, means appeal dismissed, and immediately I filed the title appeal along with an application under section 5 and 14.
How title appeal is maintainable, sir? Title appeal is not maintainable. Order 21 rule 97.
Kindly turn to order 21 rule 103.
Sir,
I filed means appeal. I filed means appeal, obtained an order of stay. Respondent appears and raised the issue before the appellate court that order 21 rule 97 doesn't come under order 43. Therefore, means appeal does not lie. Dismissed my appeal, and therefore I immediately filed on title appeal because it is the deemed degree order allowing police help. And
where is the earlier order?
I am
Rejecting the miscellaneous appeal.
Order 39 is the order, my lord, where I obtained order page 39. Page 39 is the order where the stay was granted by the means appeal court. Although I filed one application to convert the means appeal into title appeal, that has also been not considered. And page 41 is the dismissal of the means appeal.
No, this is not this. Page 41 is the dismissal.
Page 41 is the dismissal of means appeal, and page 39 was the order initially granting stay. And now I'm coming against an order passed in the title appeal where the stay is refused on the ground of pendency of section 5, and the decision which was cited before the court below, the EIR 1984, that has also been misconstrued.
No, what happened here?
Yeah,
by the impugned order, what happened?
By the impugned order, interim prayer
section 5
fixed for hearing, and the stay is refused on that ground that section 5 is pending.
Yes.
My lord,
unless the section 5 is allowed, how can the stay be granted?
Yes, my lord. I am relying upon the ratio in the decision which was cited before the court below. Not only that, my lord, there are other decisions are there where it is said that court can invoke its inherent power to protect the interest of the litigants and the litigation. Is my lord AIR 1984 Calcutta 20, where I am relying upon in paragraph. I'm relying upon paragraph 10 and 13, my lord, where it is dealt with that the
order the subsequent judgment delivered by Justice Tandon. Considering this,
that I have to
please bring that. Justice Tandon has deliberated.
I'll go through it, then kindly adjourn this matter today.
On the prayer of the learned advocate for.
Good. Item 1247.
1247.
Yes.
My lord, may I have your?
I am for the petition.
You are for the petitioner?
Yes.
Who is for the opposite party?
My lord, I am appearing on behalf of the.
But
Yes.
my suit is for declaration of tenancy right. In such a suit, not the plain starts at page in page
What is the application for?
application for repair. But I am protected
Allowed.
by an order of injunction rejected. Kindly see the reasoning. Lord, my application is at page 70 of my lord's brief. I have mentioned the schedule, what I wants to replace, only two portion. Page 71, schedule of repair, and details given at page paragraph 3.
Details given at
Paragraph 3 and 4, my lord.
Yes, no reasons has been assigned.
But this cannot be said to be a reason, my lord, when I am protected by an order of injunction, and this will not create any equity in their favor.
Yes.
My lord, it is
Who
admitted.
will argue? You will argue or yes?
It is admitted position that he is neither a tenant nor the legal heir of the tenant. It is admitted. Kindly come to annexer. Kindly come to page 37.
Sir, he is in possession.
His counterclaim is
That-
for eviction.
He is in possession.
Yes.
So
I
you
am
have
not-
filed a suit for eviction.
No, in his plaint, I have filed written statement for
All right.
eviction.
With counterclaim for his eviction.
My lord.
So since he is in possession, let him repair. He will get a repaired house when he will get possession.
No, my lord, that is not the correct. My lord, what he wants to do.
What I will direct reconsideration, no reasons has been assigned. Choice is yours. I will remand this matter application for fresh consideration. Nothing has been.
My lord,
no
one thing
reasons
may
has
be
been
con-
assigned.
my lord,
Or I can allow the repairing application that can
no
be done.
commission has been held, my lord. What repairing they want to do?
I have
They-
noticed.
Oh, you want that? You want that? All right. I will revive this application. I will give them liberty to take steps.
ঠিক আছে দাও দশ ওরা একটা পয়েন্ট তুলেছে
My lord, do that, my lord.
You want that? Or you want this to be allowed from here? What do you want?
My lord, may I request one thing, my lord? It is admitted position that he is not a tenant nor a legal heir. If this
But
application
admitted
is
position is that
is
he is in
possession.
possession.
But this order should not be contemplate that the illegal possession of the petitioner should be legalized.
That should not be. So then I will allow it.
My lord.
All right.
But consent may not be
No,
required.
no, no. No consent, nothing. Yes, this application under Article matter.
Item number 1251.
Apology for interrupting in between, my lord, in item number 1178. My lord, I was on my legs in another.
1178. Yes, sir, please wait. Yes, call the next matter. Item number?
1251. 1251.
Who is appearing? Yes, Mr. Mukherjee. Who is opposing you?
Yes.
Is this for the first time or no?
First time also. It's appearing for the first time.
Yes.
Very short point. My lord, in a cooperative matter, my lord, I applied. I am the nominee in respect of a cooperative plot. I am the nominee of my husband. Good, bad, indifferent, my lord, the cooperative society cancelled my membership. I challenged that cancellation.
You are a nominee.
I am a nominee.
So you are not yet a member.
Not cancelled my, my lord, application for being a member as a nominee. So, my lord, the cancellation was done by, my lord, the cooperative society, which is the subject matter of challenge. After cancellation, my lord, they allotted the property to somebody else. So, my lord, I filed, my lord, a proceeding under 102. In that proceeding, my lord, an application under Order 7, Rule 11 has been taken out by the defendant to contend that the cause of action pleaded in my application was very sketchy and it did not have a cause of action. I took out an application for Order 6, Rule 17. Previously, I also amended my application. The next amendment, which is the subject matter here, was
shows that your application was sketchy when we applied for amendment.
I wanted to, my lord, give a better particular so far as, my lord, the cause of action.
That
So the point here was that the learned judge, the first, my lord, the joint registrar, stated that, my lord, my application under Order 6, Rule 17 should be heard prior to hearing of the Order 7, Rule 11. That is what it is. In appeal, my lord, it was reversed. In appeal, it said that the Order 7, Rule 11 should be heard first and then my Order 6, Rule 7. So that is, your lordship will kindly come to, my lord, the impugned order. Lord, the operative portion, Lord, page 12.
Page 12.
Lordship.
Yes.
So from the above judgment, it is crystal clear, relying upon 2016 volume 14. This judgment says that, my lord, during the pendency of Order 7, Rule 11, the should not be disposed of. That was not the ratio. So from the above judgment, it is crystal clear to us that when the application under Order 7, Rule 11 of CPC is filed by the adverse party, in that event, it is the duty of the court or the arbitrator, as the case may be, to hear the matter first. So,
which portion you are placing?
But page 12, internal page 12.
Yes, so from the judgment, it is clear.
Yes. That when the application under Order 7, Rule 11 of the CPC is filed by the adverse party, in that event, it is the duty of the court or the arbitrator, as the case may be, to hear out the matter first.
Oh, there is two from the above judgment. I was looking at
the Supreme Court is quoted. I'm just cutting short
one. So that was not matching.
Short my Lord, submission because, Lord, of the
filed by the adverse party. In that event, it is the duty of the arbitrator to hear out the matter first. Which matter first? Oh,
Order 7, Rule 11. Then, your lordship, kindly proceed. Here in our present case, we find that in spite of pending application under Order 7, Rule 11 of CPC with a prayer for rejection of plaint, the learned joint registrar of cooperative societies KMH did not consider the matter. On the contrary, he allowed the application under Order 6, Rule 17 of CPC. It has been mentioned by the learned lawyer for the appellant at the time of hearing that there were other two applications under Order 6, Rule 17 of the CPC filed by the plaintiff were pending. Without dispose of the same, the third application under Order 6, Rule 17 of the CPC were taken up and disposed of accordingly. There
is substance in the argument of Mr. Yes, call the next matter.
Item number 1259.
Pass over next.
63. Item number 1263.
May I come back tomorrow?
Tomorrow, long matter.
It will take some time.
And 64, my lord, are two correct.
Take some time.
What is the issue?
Maintenance.
Maintenance, my lord,
Maintenance.
I have to show before your lordship how it has been calculated and where it has gone wrong.
You are for the
Wife,
and for the husband,
you want enhancement.
lordship, and he is asking for deduction.
I will also show from lord the order itself that.
I
where
think
the order
both
has-
is to be rejected. That's the easiest way. That's the easiest way to confirm the.
I have a calculation. I'll come back with a calculation to show my lord that how there has been a suppression.
Lord, I have made a chart ready also.
That is, my lord, I also have a chart ready. So, my lord, your
Alright.
lordship has to, my lord.
Not today, next. 6-3 and 6-4.
6 lord 6-4. But it will
Yes.
remain in the list for tomorrow. This will remain in the list.
Where it will go that I. Yes, next.
Lord, in that case,
Yeah, kindly, my lord.
in that case, I'll press it.
I will not be very, my lord, lengthy in our argument.
Yes,
In that
next.
case, we'll press it. But
1269.
1269.
No,
বেরিয়ে চলে গিয়ে বুঝতে পারছি না তো।
but will kindly retain in the list.
Yes, next.
কিন্তু বড় বড় উকিলরাও তো বসে আছে সিনিয়র অ্যাডভোকেট দেখো এখন বাপি বসে আছে কেন পাঁচটা বাপি তুমি পাঁচটা অবধি বসে আছো ঠিক কথা
Cholo, ডাক।
My lord, in 1178, my lord, I was on my legs in another court, my lord. I'm late by Mr. Siddharth Banerjee, my lord. He's in honorable, he's before honorable Supreme Court, my lord, today. My lord, kindly, my lord, keep it on Friday, my lord.
Who is your other side?
Yes.
He's opposing.
My lord, I have requested
He's
him.
opposing. Convince him.
2 days, my lord, keep the vacating, my lord. My lord, for 2 days, don't vacate, my lord. The interim order, my lord.
For 2 days.
Yes, my lord, Friday, my lord, kindly list the matter, my lord, it will
Not
be.
Friday. Tomorrow it will be taken up.
My lord, tomorrow he's coming back, my lord.
The revision is not maintainable. The mediation मामला कौन?
So Monday, let's keep it on Monday.
Lord, your lordship.
Tomorrow.
Lord,
Lord, 5 times the matter has been taken up.
Yes, my lord, I understand, my lord.
Chatterjee is junior is opposing. Mr. Chatterjee.
My lord, he is before honorable Supreme Court. He is
His
requesting,
junior
my
is
lord.
he's a creature of instructions, madam. He's a senior advocate.
Yes, my lord, I
So
understand.
he cannot go beyond the
My lord-
instructions of his advocate
My
of
lord, he
record.
will be traveling back tomorrow, my lord.
Convince him.
He said tomorrow I'll talk to him.
My lord, till tomorrow, my lord, don't vacate, my lord. It's a request.
Item number 1178. 1178 টা তাহলে রেখে দিন।
Lord,
Vacating. Yes, Mr. Ghosh, what happened?
item 32, Lord, I was on the, I was here, but one matter was taken up in court number.
But when it was called on, you are not there.
Lord, yes. Lord, password, it has been
ये दे दो.
Customer, it will.
Well, at 1178 may be the first matter under that fixed monthly list. Well, tomorrow.
I think Lord, the other two matters are before that.
दो स्नेहा जल्दी.
Well, that